ನಟರಾಜ್ ಪೆನ್ಸಿಲ್ ಖಾಲಿ ಆಗೋಯ್ತಾ? ಇನ್ನ ಇದಾವ? ಹಾ, ನಟರಾಜ್ ಇದ್ರೆ ನಂಗೆ ಕೊಟ್ಬಿಡಿ. ಕಾಲ್ ಇದೆಯಾ, ಕೊಡ್ತೀರಾ? ಇದು ಇಟ್ಕೊಂಡಿರ್ತೀನಿ ಆಮೇಲೆ ನಾವು.
ಬೀಯಿಂಗ್ ಸ್ಪೋಕ್ಸ್ಮನ್ ಕೊಡ್ಲಾ?
ಸಾಹೇಬ್ರು ಬರ್ಬೇಕು. ನೆನ್ನೆರಾ? ಹೇಳ್ಬಿಟ್ಟು
ಅಲ್ಲಿ 6ನೇದು ಇದೆ.
ವಿಡಿಯೋ ಆಡಿಯೋ ಎಲ್ಲ ಬಂದ್ ಮಾಡಿ ಹೋಗ್ಬಿಟ್ಟ. ನಾನು ಇದೇನು ಬರ್ತಾ ಇಲ್ವಲ್ಲ, ವಿಡಿಯೋ ಆಡಿಯೋ ಎಲ್ಲಾದ್ರದ್ದು ಬಂದ್ ಮಾಡಿ ಹೋಗ್ಬಿಟ್ಟ. ನಾನು ಯಾವ್ದು ಬರ್ತಾ ಇಲ್ವಲ್ಲ ಅಂತೀನಿ. ಟೈಮ್ ನೋಡೋದು 10:37 ಆಗ್ಬಿಟ್ಟೆ. ಇವತ್ತು ಬೇರೆ ಲೈವ್ ಐತೆ. ಆಯ್ತು ಕತೆ ನಮ್ದು. ಹಾ, ಆ ಟೆನ್ಷನ್ ಅಲ್ಲಿ ಗೊತ್ತಾಗಲ್ಲ. ಈಗ ನಾನೇ ಗಾಬರಿ, ಅಲ್ಲೂ ಹಂಗೆ ಮಾಡೋನು, ಇಲ್ಲೂ ಹಂಗೆ ಮಾಡೋನು. ಇದೇನು ಎಲ್ಲಾರು ಬರ್ತಾವ್ರು, ನಮ್ದೇ ಇಲ್ವಲ್ಲ ಚಿತ್ರ ಅಂತ. ಓಪನ್ ಕೋರ್ಟ್ ಇತ್ತಲ್ಲ, ಕರ್ಸಿದ್ರಲ್ಲ.
ಇವ್ರು ಇರ್ತಾರೆ, ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ. ನೀವ್
ಹೇಳ್ಬಿಟ್ಟು ಕೊಡಿ ಸರ್. ರಾಜ ಅವ್ರದ್ದು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕೊಡಿ. ರಾಜ ಅವ್ರದ್ದು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕೊಡಿ.
ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ನಿನ್ನೆ ಫ್ಯೂಚರ್
page wise adjournment, list number 1, page number 1, serial number 1 to 5, page number 2, serial number 6 to 10.
Serial number 1, my lord.
serial number
1. Seeking for some time, my lord. Seeking for some time.
unfiling of statement of objection by the
For the respondent.
You are appearing for whom?
Respondent.
Respondent. At the request of counsel for the respondent. Is this matter next week?
Serial number 6, my lord. There is one more connected matter, my lord. CP 342 of 22.
You are appearing for
Respond.
learned counsel for the respondent submits that this petition may be called along with the souls.
Page number 2, serial number 7 to 10. Page number 3, serial number 11 to 16.
My lord, serial number 14, my lord, may kindly call next week.
14. Yes. At the request of counsel for the respondent number 2, is this matter next week?
Page number 4, serial number 17 and 18.
Serial number 17, my lord, it has to be connected along with 2093 of 2020.
You are appearing for
Appellant,
Prakash H.
please.
The request of counsel for the respondent. Is this matter along with the souls?
My lord, serial number 17.2. Actually, my name is shown for respondent number 1. My name can may be deleted, my lord. I think Mr. Rushbedraya has filed the wakalat on behalf of
13.
sorry, Palakshaya. Palakshaya has filed. On behalf of
Palakshaya has
KSR.
filed an appeal, yes, he has filed. Adralli 17.2 ali office is directed to delete the name of D. Vijay Kumar for respondent number 1. Show the name of B. Palakshaya. Yes.
He is already appearing in all the matters.
Yes. He
Page
has
number
filed
5,
an
serial number 19 to 21. Page number 6, serial number 22 to 25. Page number 7, serial number 26 to 28. Page number 8, serial number 29 to 33. Page number 9, serial number 34 to 39. Page number 10, serial number 40 to 45.
Party petitioner.
40.
Senior date. Senior.
Which one? 40. Yes. You are appearing for
Petitioner.
at the request of counsel for the petitioner. Leave this matter next week. Yes. Hmm. At the request of counsel for the appellant, leave this matter next week.
Page number 11, serial number 46 to 49. Page number 12, serial number 50. List number 1, serial number 1 adjourn, serial number admission matter, serial number 2, Avani Chokshi for petitioner, VD Raviraj.
Petitioner in this case, my lord. My lord, this is a transfer petition filed by one woman, my lord, who's residing in Mangalore, Mysore, to transfer the case from Chikmagalur to Mysore, my lord. What has happened, my lord? The plaint which we are seeking transfer, my lord, may find at page number 8, my lord.
Now, where is your opponent? Password.
Please, maybe passed over, my lord.
Serial number 3, Kirti Prasad DC for petitioner, Shivaramu HC.
For petitioner, your lordship, I'm filing a detailed statement of objection, your lordship. I've served the copy in the council.
Very space, my lord. This is a matter third time. Last time they said took time. They are not keeping well. Today they are.
We are filing, your lordship, it is ready.
Take
I'm
it,
ready to, it's a transfer matter. I am ready to go on with the matter, irrespective of what he is going to file. Why he should drag the matter, I don't understand.
Yes, mister.
Your lordship, the respondent husband has filed a petition for decree of divorce on the ground of cruelty before the family court at Bangalore, your lordship. Your lordship, the petitioner has also filed a complaint before the Rajarajeshwari Nagar police and
Petition is by that wife.
wife, your lordship. For transfer of this MC petition from Bangalore to Tumkur, your lordship.
Bangalore to Tumkur.
Tumkur, your lordship.
Now this, where is that petition? That is,
Last occasion, your lordship clarified, my lord, the evidence can go on here. Because last one day, evidence is there. Then matter will be posted for argument. Therefore, your lordship said that, my lord, on the last occasion, last 3 occasions back, my lord, that interim order granted by this court will not coming in the way of conducting the proceedings in the trial court.
what has happened?
Yes,
there?
we are conducting, there is an IA pending.
They filed application one there, my lord. They want to insist, my lord, to go on with that one instead of going on with the cross examination.
No, the application was already filed and it was pending under section 24 of Hindu Marriage Act. But that has to be decided. If it is decided, we'll go on with the cross examination.
Therefore, one thing,
Yes,
let that application, whatever is there, let the proceedings go on here.
yes, your lordship.
After that, when the case of evidence will
limit.
comes, we'll
Time
take this
limit
matter.
may be
Yes.
prescribed, your lordship. Time limit may be prescribed so that
see,
matter could be
now
disposed of.
that as it is,
Yes,
there is no petition for CP. Now the case is pending.
yes, your lord.
Whatever that IA, he has the right to file, you objected.
Yes,
Let the court proceed.
yes, your lord.
Only the time of evidence of the petitioner, then we have to consider whether it has to be transferred or
correct.
not.
Please, your lordship.
Proceed there, then
There
we'll
are-
have it.
Please, your
Page
lord.
48, my lord, may kindly see, my lord, in the application filed by me, my lord, for vacating stay.
Hmm.
How many times cost has been imposed on them, my lord, and thereafter they filed this petition, my lord, they changed 4 councils.
Now that
Yes, my lord.
I have made it clear,
Yes, my lord.
let
That's
the
correct.
trial court go on with that matter.
Yes, sir.
He is also ready. If he is not,
Yes.
then they will dismiss. It is for the court to
Yes,
decide.
your lord.
Please, your lord.
I am no,
Have it.
I have no objection.
Yes. Please this matter,
Let him proceed with the matter, my lord.
Yeah, we are
That's all my-
proceeding, your lord.
that you object before that presiding officer. That is not before me. Yes.
My lord may say so, my lord, the application may be, any
That
application.
that cannot be, that you object it there. If they pass an order, then
Yes.
you have a right of filing in a petition. Yes.
ಅದರ್ವೈಸ್ ಅಲ್ಲಿ ಹೋಗಿ ಸುಮ್ಗೆ ಟೈಮ್ ಕೇಳಿದ್ರೆ ಅವ್ರು ತಾನೇ ಕೋರ್ಟ್ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಈಗ 3 ಸಾರಿ ಕೇಳಿದ್ರು ಅಬ್ಜೆಕ್ಷನ್ಗೆ ಅಂತ ಈಗ ಅಬ್ಜೆಕ್ಷನ್ ಫರ್ದರ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೋದಕ್ಕೆ ಹುಷಾರಿಲ್ಲ ಅಂತೇಳಿ ಟೈಮ್ ತಗೊಂಡು ನೌ ದೇ ಫೈಲ್ ದಿಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಫರ್ದರ್ ಅಬ್ಜೆಕ್ಷನ್ ದೇ ಆರ್ ನಾಟ್ ರೆಡಿ ಟು ಫೈಲ್ ಇಟ್ ಇನ್ ದಿ ಕೋರ್ಟ್ ಇಟ್ ಸೆಲ್ಫ್ ದೇ ವಾಂಟ್ ಟು ಫೈಲ್ ಇಟ್ ಇನ್ ದಿ ಆಫೀಸ್ ದಟ್ಸ್ ಹೌ ದೇ ಡ್ರಾಗ್ ದಿ ಮ್ಯಾಟರ್ ವಾಟ್ ಈಸ್ ದಿ ಫನ್ ಇನ್ ಡ್ರಾಗಿಂಗ್ ದಿ ಮ್ಯಾಟರ್ ಮಿಲಾಡ್ ಇಸ್
There you object for that, granting a time there, even
Please,
for
sir.
application.
Yes.
Go on with that matter.
Yes, sir.
Much of.
Is this matter of 3 weeks? Yes.
Serial number 4, Veeresha K for petitioner, but Ramachandra.
That one date may be given, your lordship, after 2 weeks or 3 weeks, your lordship. 2 weeks, your lordship. We will know the procedure.
Is this matter on 29th?
Yes, your lordship.
Yes. Let us hear.
Grateful.
Serial number 4, Viresha K.
Petitioner in this case, my lords.
Hmm.
This is the my lord's wife's petition, my lords. Seeking my lords transfer of MC petition, my lords, which has been filed by the husband, my lords, in Shivamogga, my lords. This petition, my lords, seeking my lords, transfer of the MC petition from Shivamogga to Hospeta, my lords, where the petitioner is residing, my lords, with our parents, my lords.
ಸಣ್ಣ ವಾಯ್ಸ್ ಬರುತ್ತೆ ಇದ್ರಲ್ಲೆಲ್ಲ ಮ್ಯೂಟ್ ಮಾಡ್ಬೇಕನ್ನ ಚಿರ್ ಅಂತ ಯು ಜಸ್ಟ್ ಮೇಕ್ ನೋಡಿ
With kind permission, my lord. Audio illa. Audio is not there, my lord.
ಪೋರ್ಟಲ್ದು ಆಡಿಯೋ ಇಲ್ಲ ಸ್ವಾಮಿ.
Yes.
Please.
ಅಲ್ಲೂ ಬಿಟ್ಟು ಮಾಡಿಲ್ಲ.
Yes.
Not this is case.
Serial number 9, Ravish Bendy for appellant, connected matter, KT Gurudeva Prasad.
Insurer appeal on liability on involvement of the vehicle, please. Madam.
Yes.
Complaint given by the son of the deceased next day. The TCR is there, please.
Okay.
In FIR,
Now, how that accident has occurred? And petitioner brief is
Was
that
walking on the extreme left side of the road
walking.
and a minibus came and dashed against him and he died on the way to the hospital.
Yes. Now, yes, Vinny. What is your content?
may I submit, please?
Yes.
In complaint, FIR, inquest, and all other documents, madam, there is no number of unknown vehicle.
Yes.
Charge sheet ಅಲ್ಲಿ ಮಾತ್ರ ನಮ್ಮ ವೆಹಿಕಲ್ ತೋರಿಸ್ತಾರೆ. ಆಮೇಲೆ ದಟ್ ಅಕ್ಯೂಸ್ಡ್ ಬೆಳೆ ನೆಕ್ಸ್ಟ್ ಡೇ ಬಂದು ಅಪಿಯರ್ ಆಗಿ ನಾನೇ ಆಕ್ಸಿಡೆಂಟ್ ಮಾಡಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಸರ್. ಎಕ್ಸಿಬಿಟ್ R1 ಪ್ಲೀಸ್ ಮೇಡಮ್.
Yes.
On all the documents except a charge sheet, there is no our vehicle is not in this case, please.
Yes. What is the finding of the trial court?
ನಮ್ಮ ಮೇಲೆ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಏನ್ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
Para 11.
Para 11. Yes. Read, Mr.
The argument, the learned counsel for the respondent contended that the vehicle in question is not involved in the accident, but it has been falsely implicated. But this contention of the respondent is not acceptable because very evidence of RW1 examined by the respondent number 1 clearly disclosed that after due inquiry and investigation, a charge sheet is filed against the driver of the offending vehicle, RW1 being IO in the said charge, has clearly spoken that while drawing the measure, one Manjunath has given statement about the involvement of the offending vehicle, and after that, she made thorough investigation and filed the charge sheet. In this regard, she also produced a statement given by the said Manjunath as per Exhibit R3. The learned counsel for the respondent contended that the said statement is created after receiving the summons from this court. But this contention of the respondent is also not acceptable because Exhibit R3 statement is recorded on 13/5/2016 itself, and the said Manjunath is cited as CW4 in the charge sheet produced as per Exhibit P5. His statement is part and parcel of the charge sheet which is filed on 6/6/2016 itself. Such being the case, version of the respondent that the said statement is created after receiving the summons from this court is not acceptable and believable. Therefore, under these circumstances, relying upon the oral evidence of PW1 coupled with the exhibits P1 to P8, this court is of the opinion that the driver of the offending each or mini bus so and so drove it in a rash and negligent manner so as to endanger human life, dashed against the G. Krishna Reddy, resulting which he sustained grievous head injury and died on the way to the hospital. The Lordship may kindly see 162 statement recorded by the investigating officer under criminal procedure code is an evidence admissible in the evidence that is reported in 2016-3 Supreme Court page 108, 2016 volume 3 SCC 108, and 2022 volume 10 Supreme Court 512. in Janabi case.
Yes.
So owner and driver not disputed the involvement of the vehicle, then court has to believe.
Is that treatment?
Treatment. One more, 1981, that is KLJ,
Hmm.
178.
Judgment.
That is a bench judgment of this honorable court. It is my case only. There also, this court has considered the 162 statement and come to the conclusion that can be admissible in evidence and it can be relied. Sorry, not bring the citation, sorry.
No, just see that we'll get it. The month has given a statement about.
And in fact, RW1 is the investigating officer.
He has been
clearly
examined.
given evidence.
Where is that statement of that owner? He has admitted that.
R3, exit R3.
No, that Manjunath is the owner,
Manjunath is the driver.
driver.
Not only that, the investigating officer went to the spot and
Yes.
the other people who were gathered there also, they gave information.
Yes. Yes, Mr. Bint. Yes.
Please, madam. We have examined the IO also.
Hmm.
She deposed, kindly take the exhibit R1, please, madam.
R3, that is the statement of one eyewitness.
Yes. We'll see. R1.
Exhibit R1, please.
R1.
Exhibit R1. May I read, please, madam? ಹೆಬ್ಬಾಳ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ನಾನು ಮೊದಲು ಕರ್ತವ್ಯ ಮಾಡಿದ್ದೇನೆ ಅಪರಾಧ ಸಂಖ್ಯೆ
Not exhibit R3. You are seeing that R1 statement.
R1 statement.
RW1.
RW1.
ನೀವು ಅವ್ರ ಹಂಗಾಗ R3 ಕೊಡಿ.
RW1 statement. ಏನ್ರ?
ನೀವು ಓದ್ತಾ ಇರೋದು.
ಅದೇ ಡಿಪೋಷನ್ ಆಫ್ ದಿ RW1 ಪ್ಲೀಸ್.
You said R1, therefore he given that complaint.
ಇಲ್ಲ ಎಕ್ಸಿಬಿಟ್ R1 ಇಲ್ಲ ಸರ್, ಡಿಪೋಷನ್ ಆಫ್ R1 ದ IO. ಎಕ್ಸಿಬಿಟ್ R1 ಅದು ನೆಕ್ಸ್ಟ್ ಇದೆ, ಅದು ಓದ್ತೀನಿ ಸರ್ ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್.
ಅಲ್ಲ ಆಯ್ತು ಅವ್ರು.
RW1 ಪ್ಲೀಸ್.
Yes.
ಮಿಲಾಡ್ ಹೆಬ್ಬಾಳ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ನಾನು ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ್ದೆ. ಅಪರಾಧ ಸಂಖ್ಯೆ ಸದದಲ್ಲಿ ಸಂಪೂರ್ಣ ತನಿಖೆ ಮಾಡಿರುತ್ತೇನೆ. ದಿನಾಂಕ 12/5/16 ಸಂಜೆ 6 ಗಂಟೆಗೆ ಅಪರಾಧ ದೂರು ಹೇಳಿರುತ್ತಾರೆ. ಸದರಿ ದೂರು ಪ್ರಸನ್ನ ಕುಮಾರ್ ರೆಡ್ಡಿ ಅವರು ಮಾರನೇ ದಿನ ಬೆಳಗ್ಗೆ ಕೊಟ್ಟಿರ್ತಾರೆ. ಸದರಿ ದೂರು ಈಗ ನಾನು ನೋಡಿರುತ್ತೇನೆ. ನಿಶಾನ ಪಿ ಒಂದು ಗೊತ್ತಿಲ್ಲದ ನಂಬರ್ ಆಗಿರುತ್ತದೆ. ನಂಬರ್ ಗೊತ್ತಿಲ್ಲದ ವಾಹನದ ಅಪಘಾತ ಆಗಿರುತ್ತೆ ಎಂದು ಉಲ್ಲೇಖವಿದೆ. ಅನ್ನೋನ್ ವೆಹಿಕಲ್ ಇನ್ಕ್ವೆಸ್ಟ್ ಅಲ್ಲೂ ಅದೇ ಇದೆ, ಪಂಚನಾಮದಲ್ಲೂ ಅದೇ ಇದೆ. On all the statements. 7.
Wait. Some disturbance is there. Yes, now you argue.
4 persons gave a statement in the IO. All are said that unknown vehicle only. She further deposed ಅವಳು ಹೇಳ್ತಾಳೆ ಅವರು that IO 13ರಂದು ಅಪಘಾತ ವಾಹನ ರಾಜು the driver of the vehicle is not Manjunath, it is Raju, please, Your Honor. As per this, our ಇದರ ಪ್ರಕಾರ ಚಾಲಕ ರಾಜು ಎಂಬುವನು ತಾನಾಗಿಯೇ ವಾಹನ ಸಮೇತ 1 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಠಾಣೆಗೆ ಹಾಜರಾಗಿ ವಿಚಾರಣೆ ಮಾಡಿ ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾನೆ. ಈ ಬಗ್ಗೆ ಸಾರ್ವಜನಿಕರು ಕೂಡ ನಮಗೆ
ಹೇಳಿದ್ದಾರೆ.
ಮಾಹಿತಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಷ್ಟರಲ್ಲಿ ಆರೋಪಿಯು ಠಾಣೆಗೆ ಬಂದು ಹಾಜರಾಗಿ ದೂರನ್ನು ಪಡೆದುಕೊಂಡು ತಕ್ಷಣ ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿರ್ತೇನೆ. ಅಷ್ಟರಲ್ಲಿ ಬಿಳಿ ಐಚರ್ ವಾಹನ ಹಾಗೂ ನಂಬರ್ ಕೂಡ ಸ್ಥಳದಲ್ಲಿ ನಮಗೆ ಹೇಳಿರುತ್ತಾರೆ. ಈ ರೀತಿ ಸಾರ್ವಜನಿಕರು ಹೇಳಿರ್ತಾರೆ. ಲಾರಿಯಲ್ಲಿ ಮರಳು ಕೆಲಸ ಮಾಡುವವನು ನಮಗೆ ಈ ಮಾಹಿತಿ ಕೊಟ್ಟಿರ್ತಾರೆ. ಆದರೆ ಹೆಸರು ಮೆರೆತಿದ್ದೇನೆ. ಆರೋಪಿ ಠಾಣೆಗೆ ಹಾಜರಾಗಿ ಹೇಳಿಕೆಯನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕೊಂಡಿರುತ್ತೇನೆ. ಸದರಿ ದಾಖಲೆಯ ಸ್ವಯಂ ದೃಢೀಕೃತ ದಾಖಲೆ ಆಗಿರುತ್ತದೆ. ಎದುರುದಾರರು ಮತ್ತು ಅರ್ಜಿದಾರರ ಪರ ವಕೀಲರು ಅದನ್ನು ನಿಶಾನೆ ಮಾಡಲು ಯಾವುದೇ ತಕರಾರು ಮಾಡಲು R1 ದಟ್ ಇಸ್ ಎ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ದ ಯು ಪ್ಲೀಸ್ ಮ್ಯಾಮ್. ಸದರಿ 13/6/19 ಬೆಳಗ್ಗೆ ವಾಹನ ಸಮೇತ ಠಾಣೆಗೆ ಹಾಜರಾಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಪ್ರಕರಣ ದಾಖಲು ಮಾಡಿದ ಪ್ರಥಮ ಮಾಹಿತಿ ವರದಿ ಸಂಬಂಧಪಟ್ಟ ಠಾಣೆಗೆ ಕಳಿಸಿರುತ್ತೇನೆ. 13ರಂದು 11-12 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಶವ ತನಿಖಾ ವರದಿಯನ್ನು ಮಾಡಿರುತ್ತೇನೆ. ಈಗ ನನಗೆ ತೋರಿಸುವ ದಾಖಲೆ ಶವ ತನಿಖೆ 7 ಆಗಿರುತ್ತದೆ. ಈಶಾನ್ಯ R2 ಪ್ಲೀಸ್, ದಟ್ ಈಸ್ ಒಟ್ಟು ಸಂಖ್ಯೆಯಲ್ಲಿ 3ರಲ್ಲಿ ಗೊತ್ತಿಲ್ಲವೆಂದು ದಾಖಲಾಗಿರುತ್ತೆ ಎಂದರೆ ಸರಿ. ಅದೇ ದಿನ ನಾನು ಸ್ಥಳ ನಕ್ಷೆಯನ್ನು 8:30ರಿಂದ 9:30ವರೆಗೆ ಸಮಯದ ಮಾಡಿರುತ್ತೇನೆ. ಹಾಗೂ ಸ್ಥಳದಲ್ಲಿ ಕಚ್ಚಾ ನಕಾಶೆ ಕೊಟ್ಟಿರ್ತೇನೆ. ನಾನು ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಆಪಾದಿತ ವಾಹನ ಪ್ರಕರಣದಲ್ಲಿ ಸಿಲುಕಿಸಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಮಹಜರ್ ಸ್ಥಳದಲ್ಲಿ ಬರೆದಿಲ್ಲ, ಠಾಣೆಯಲ್ಲಿ ಬರೆದಿದೆ ಎಂದರೆ ಸರಿ. ಮಹಜರ್ನಲ್ಲಿ ವಾಹನ ಸಂಖ್ಯೆ ಉಲ್ಲೇಖ ಮಾಡಲಾಗಿದೆ ಎಂದರೆ ಸರಿ. ಮಹಜರ್ನಲ್ಲಿ ಉಲ್ಲೇಖ ಮಾಡಿದ ನಂತರ ನ್ಯಾಯಾಲಯಕ್ಕೆ FIR ಕಳಿಸಿದಾಗ ಆ ನಂಬರನ್ನು ಉಲ್ಲೇಖ ಮಾಡಿರುವುದಿಲ್ಲ. ಇವ್ರು FIR ಕಳಿಸ್ತಾರಲ್ಲ ಸರ್, ಆಮೇಲೆ ದಟ್ ನಂಬರ್ ಟು ಬಿ ಗಿವನ್ ಟು ದಿ ಲರ್ನೆಡ್ ಕನ್ಸರ್ನ್ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್, ಅದು ಕೊಡೋದಿಲ್ಲ ಅವರು. ಪ್ರಥಮ ಮಾಹಿತಿ ವರದಿ ತಯಾರಿಸಿದ ನಂತರ ತಕ್ಷಣ ತನಗೆ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕಳಿಸಿರುತ್ತೇನೆ ಎನ್ನುತ್ತಾರೆ. ಸ್ಥಳದಲ್ಲಿ ಅಪಘಾತಪಡಿಸಿದ ವಾಹನದ ನಂಬರನ್ನು ನಮಗೆ ಮಹಜರ್ ಮಾಡಿದಾಗ ತಿಳಿಸಿರುತ್ತಾರೆ. ಅವರ ಹೆಸರು ಮರೆತು ಹೋಗಿರುತ್ತೆ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ಖಂಡಿತವಾಗಿ ಪರಿಶೀಲನೆ ಮಂಜುನಾಥ ಎಂಬುವರು ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಿ ಮಂಜುನಾಥ ಎಂಬುವರು ವಿಚಾರಣೆ ಹೇಳಿದ್ದಾರೆ. ನಂತರ ಅಲ್ಲದೆ ಹೇಳಿಕೆಯ ಪ್ರತಿಯನ್ನು ಕೂಡ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರಿಸುತ್ತೇನೆ. ಸದರಿ ಹೇಳಿಕೆಯನ್ನು ಹಾಜರುಪಡಿಸಲು ಇಬ್ಬರು ವಕೀಲರು ಯಾವುದೇ ತಕರಾರು ಮಾಡಿರುತ್ತಾರೆ. ದಟ್ ಇಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ದಟ್ ಮಂಜುನಾಥ್ ಪ್ಲೀಸ್. ಮಂಜುನಾಥ ಸ್ಥಳ ಸಾಕ್ಷಿಯಾಗಿ ಮಾಡಿಕೊಂಡಿರುವುದಿಲ್ಲ. ನಿಶಾನೆ ಪಿ ಹೇಳಿಕೆಯಲ್ಲಿ ಬರೆದುಕೊಂಡ ಸಮಯದಲ್ಲಿ ಟೈಮ್ ಹಾಕಿಲ್ಲ. ಸೊ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಮೆನ್ಷನ್ ದಿ ಟೈಮ್ ಇನ್ ದಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ದಿ ದಟ್ ಮಂಜುನಾಥ್ ಪ್ಲೀಸ್. ಸಮನ್ಸ್ ಬಂಧನ ಸ್ಥಳಕ್ಕೆ ಮಾಡಿದೆ. ಸರಿಯಾದ ಕಾರಣ ಅದರಲ್ಲಿ ಹೇಳಿಕೆ ಅವಧಿಯಲ್ಲಿ ಉಲ್ಲೇಖ ಮಾಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅವರು ಸ್ಥಳದಲ್ಲಿ ಇದ್ದು ಮಾಹಿತಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವರನ್ನು ಸ್ಥಳ ಮಹಜರ್ ಸಾಕ್ಷಿಯಾಗಿ ಮಾಡಿದ್ದಾರೆ ಎಂದರೆ ಸಾಕ್ಷಿದಾರರು ಅವರು ಸ್ಥಳದಲ್ಲಿ ಇದ್ದು ಅಪಘಾತವನ್ನು ನೋಡಿದ್ದರಿಂದ ಅವರು ಪಕ್ಷದ ಸಾಕ್ಷಿಯನ್ನು ಮಾಡಲಾಗಿದೆ ಎನ್ನುತ್ತಾರೆ. ಅಪರಾಧಿತ ಒಳಗಡೆ ಉತ್ತರ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದರಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P3 ಅದರಲ್ಲಿ ಡೇಟ್ ಇಲ್ಲ, ಏನಿಲ್ಲ. ಆಮೇಲೆ ಎಕ್ಸಿಬಿಟ್ R1 ಅಲ್ಲೂ ಇಲ್ಲ. ಡೇಟ್ ಇಲ್ಲ, ಟೈಮ್ ಇಲ್ಲ, ಏನಿಲ್ಲ. ಅವ್ರು ಹೇಳ್ತಾರೆ ಬೆಳಗ್ಗೆ ಒಂದ್ ಗಂಟೆಗೆ ಬಂದ ಅಂತ ಅಯ್ಯೋ ಹೇಳ್ತಾರೆ ಸ್ಟೇಷನ್ಗೆ. ಅವನು ಯಾರು ದಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಗಿವನ್ ಬೈ ದಟ್ ಅಕ್ಯೂಸ್ಡ್ ನಾನು ಬೆಳಗ್ಗೆನೆ ಹೋಗಿದ್ದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
No, that, what is the date of the accident?
12/5/2016.
12/5/2016.
2016.
That's real.
12/5/2016.
ಅವ್ರು ನೆಕ್ಸ್ಟ್ ಡೇ ಹೋಗಿ ಬೆಳಗ್ಗೆ ಹೋದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾರು ದಟ್ ಅಕ್ಯೂಸ್ಡ್.
Complaint is on 13/5/2016 at 8 AM.
You have given a complaint.
Yes.
On 13 you have given.
13/5/2016,
ನೆಕ್ಸ್ಟ್ ಡೇ
8 AM morning.
13/5/2000.
16. Next, very next day. ಅದು ಮಾರ್ನಿಂಗ್ 8 ಗಂಟೆಗೆ ಹೋಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವತ್ತೇ ಮಾಜರ್ ಮಾಡಿದ್ದಾರೆ, ಅವತ್ತೇ ಸ್ಕೆಚ್ ಮಾಡಿದ್ದಾರೆ, ಅವತ್ತೇ ವಿಟ್ನೆಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ಅನ್ನೋನ್ ವೆಹಿಕಲ್. Same day, 13/5/16. ಅಲ್ಲ, ಒಂದ್ ಗಂಟೆಗೆ ಅಂತ ಹಾಕಿದಾರೆ. ಒಂದ್ ಗಂಟೆಗೆ ಅಂತ ಹೇಳಿದ್ರು. ಐವನೇ ಹೇಳೋದು. Not only on his statement, they have inquired in the area, people who gathered there, they also gave a number and the vehicle particulars.
Why in that FIR, the number is not mentioned. It has been registered in the morning. When he has given a complaint, that time that doesn't know that in the night only that he has come. The moment complaint has been lodged, they have to register a FIR. They have registered an FIR as unknown vehicle.
Correct.
You don't make it next day. Next day.
ಅಲ್ಲ, ಅದೇ ನೆಕ್ಸ್ಟ್ ಡೇನೆ ಮಾರ್ನಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ
FIR register ಮಾಡಿದ್ದಾರೆ. 13ನೇ ತಾರೀಕು ರಾತ್ರಿ he has come. That at least who caused the accident. ಇವರು ಹೇಳ್ತಾರೆ 1 ಗಂಟೆಗೆ ಬಂದ. See, 13/5/2000 ಅಪರಾಧಿತ ವಾಹನ ಚಾಲಕ ರಾಜು ಅವರಿಗೆ ತಾನಾಗಿ ವಾಹನ ಸಮೇತ ಸುಮಾರು
ಅಲ್ಲ, 1 ಗಂಟೆ ರಾತ್ರಿ ಅಲ್ಲ, 1 ಗಂಟೆ ಮಧ್ಯಾಹ್ನ 1 ಗಂಟೆ.
ಸಮೇತ ಸುಮಾರು
ಇದರಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ದಿನಾಂಕ 13/5/21 ಅಪಾದಿತ ವಾಹನ ಚಾಲಕ ರಾಜು ಎಂಬುವರು ತಾವಾಗಿಯೇ ವಾಹನ ಸಮೇತ ಸುಮಾರು 1 ಗಂಟೆ ಸಮಯದಲ್ಲಿ.
1 ಗಂಟೆ ಸಮಯ ಅಂತ ಹೇಳ್ತಾರೆ, ರಾತ್ರಿ ಅಂತ ಏನು ಹೇಳೋದಿಲ್ಲ.
ರಾತ್ರಿ ಅಂತ ಇಲ್ಲ, ರಾತ್ರಿ ಅಲ್ಲ. ಹೌದು, 1 ಗಂಟೆಗೆ ಅಂತ ಹೇಳಿದ್ರೆ.
ಯಾರು ಅಕ್ಯೂಸ್ಡ್? ರಾಜು.
ಅದು ಬೆಳಗ್ಗೆ 13/5 ಬೆಳಗ್ಗೆ ನನ್ನ ವಾಹನದ ಸಮೇತ ನನ್ನ ವಾಹನ ಹಾಜರಾಗಿ ಒಪ್ಕೊಂಡಿರ್ತಾರೆ. ಬೆಳಗ್ಗೆ
ಎಲ್ಲಿದೆ?
ಅಯ್ಯೋ ಹೇಳ್ತಾರೆ 1 ಗಂಟೆಗೆ ಬಂದ.
ಎಲ್ಲಿದೆ? ವೇರ್ ಇಸ್ ದಟ್? ಅಲ್ಲ, ಅವನದು ರಾಜುದು ಸ್ಟೇಟ್ಮೆಂಟ್ R1 ಏನದು?
ಸ್ಟೇಟ್ಮೆಂಟ್ ರಾಜು
ಡ್ರೈವರ್
ಎಕ್ಸಿಬಿಟ್ R1.
ಅದರಲ್ಲಿ ಡೇಟ್ ಇಲ್ಲ, ಟೈಮ್ ಇಲ್ಲ, ಏನಿಲ್ಲ.
ಎಕ್ಸಿಬಿಟ್ R1 ಏನಿದು? What is this exhibit?
Statement recorded by the investigating officer.
160.
Oh, 162 statement.
162 statement. Yes. 15 ವರ್ಷಗಳಿಂದ ಡ್ರೈವರ್ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದು, ಇದನ್ನ ದಿನಾಂಕ 12/9 ಸಂಜೆ ಸುಮಾರು 6:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಾನು KSRTC ವಾಹನವನ್ನು ಚಲಿಸಿಕೊಂಡು ರಸ್ತೆಗೆ ಸದರಿ ರಸ್ತೆ ಚಂದ್ರಪ್ಪ ರಸ್ತೆ ಪಕ್ಕದಲ್ಲಿ ನಡೆದುಕೊಂಡು ಹೋಗುತ್ತಿರುತ್ತಾನೆ. ಈ ಸೆಟ್ ಬೆಳಿಗ್ಗೆ ಅಂತ ಅಂದ್ರೆ ಟೈಮಿಂಗ್ಸ್ ಏನು ಹೇಳಿಲ್ಲ. ಈ ಹಸ್ ನಾಟ್ ಸೆಟ್ ಬೆಳಿಗ್ಗೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. No, 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 no. This is 160 statement. What he has stated, that has to be recorded. That's all.
ಬೆಳಿಗ್ಗೆ ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಅವ್ನು ಬೆಳಿಗ್ಗೆ ಅಂತ ಹೇಳಿದ್ದಾನ ಅಷ್ಟೇ. ಸಿ ರಾತ್ರಿ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ, ಮಾರನೇ ದಿನ ಹೋಗ್ಬಿಟ್ಟು ಅವನು ಒಪ್ಕೊಂಡಿದ್ದಾನೆ. ದಟ್ ಇಸ್ ವಾಟ್ ದಟ್ ಹಿಟ್ ಅಂಡ್ ರನ್ ಕೇಸ್ ಅಲ್ಲಿ on the spot they will escape because that there is a threat from the public. ಹೋಗ್ಬಿಟ್ಟು ಪೊಲೀಸ್ ಅಲ್ಲಿ ಸರೆಂಡರ್ ಆಗ್ತಾರೆ. ಯಾಕೆ ಅಂತಂದ್ರೆ tomorrow it's an offense. He has surrendered there, police. Yes. Which one exhibit? ಏನ ಯಾವ್ದು? ಅವ್ನು ಸರೆಂಡರ್ ಆಗ್ತಾನಲ್ಲ ವಿತ್ ವೆಹಿಕಲ್.
IM ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದು ಅದ್ರ ನೆಕ್ಸ್ಟ್ ಡೇ
ಅದೇ ಹೇಳಿದ್ 14th. ಅದು ಎಲ್ಲಿ? What is that? See what has happened here. In the 13th, he went to the police station, surrender and given that vehicle. ಮಾಡಬಾರ್ದಂತ ಎಲ್ಲಿದೆ? No, that cannot be. See, unless you have to be proved by that there was no IME report, there is no bar to conduct an IME in the morning. The one thing is, vehicle was easily available for that police because it was stationed in that police station, because he himself has surrendered. Therefore, they might have been called the RTO officer and conducted. Unless ನಿಮಗೆ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಬಾಡಿ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ 6 ಗಂಟೆ ಮೇಲೆ ಆಫ್ಟರ್ ಸನ್ಸೆಟ್ ಮಾಡಬಾರ್ದು ಅಂತ ಆತರ ಏನಾರ ಕಾನೂನು ಇದ್ರೆ IME
ಮೊದಲನೇ ದಿನನೇ ಇಂಟಿಮೇಷನ್ ಕೊಟ್ಟಿರ್ತಾರೆ.
Yes, yes, yes.
Of the respondent corporation involved in the accident, if the motorcycle of the deceased, mere involvement of the bus of the respondent corporation in the accident cannot be made the respondent to make liable to take compensation unless it is shown that accident is caused with the rash and negligence of the driver. 10 of the
Yes.
Involved the bus not be made respondent unless it can be held that the buses basis of the material on record that an accident was caused by rash and negligence.
No, is it your second point that there is no negligence on your point?
ಆಮೇಲೆ ಈ ಬಸ್ಸು ಅವರಿಗೆ ಡಿಕ್ಕಿ ಆಗಿದೆ ಅಂತ ವಿಂಡ್ಶೀಲ್ಡ್ ಈಸ್ ದಿ ಡ್ಯಾಮೇಜ್. ಬಸ್ಸು ಕೆಳಗೆ ಸುಮಾರು 4-5 ಅಡಿ ಮೇಲೆ ಇರ್ತದೆ ಶೀಟ್, ಬಾಟಮ್ ಟು ಅಪ್ ಟು ವಿಂಡ್ಶೀಲ್ಡ್ ಡ್ಯಾಮೇಜ್ ಇದೆ. ಮನುಷ್ಯನ ಯಾವ ವೆಹಿಕಲ್ ಡ್ಯಾಮೇಜ್ ಆಗುತ್ತೆ, ಸೈಕಲ್ ಡ್ಯಾಮೇಜ್ ಆಗಲ್ಲ, ಈ ಬಸ್ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ ಅಂತ ತೋರಿಸ್ತಾರೆ.
Yes. Yes.
Same application, evidence of initiation charge sheet in the criminal case showed that the seat of the deceased was traveling in the effect stayed in the pattern injury when the effect was met with an event. The evidence of the claimant that in the deceased was pedestrian, the truck
marked down in the evidence was completed. In the process of the tribunal relied upon the charge sheet, held that the deceit was traveling in the train. Whether the tribunal to finding justified effect, content of the charge sheet cannot be placed down, cannot be treated as an evidence in the case proceeding. Tribunal must rely upon the charge sheet is not completely.
It is one of the part of the evidence, not on the basis of the charge sheet. See, in that case, only on the basis of the charge sheet, they held that it is negligence. Therefore, they said charge sheet is, you can take an.
Owner, petitioner, and he was also grant they have the only hands the composition.
You have an opportunity for him to examine. That is what that in that civil and criminal matters, you have to be elicited that.
Point not necessarily a criminal. Yeah, veracity of the evidence of the EO. Oh, contradiction.
Yes, we consider. Yes. Yes, quantum, we have no this thing.
Quantum is just.
No, that your appeal is also there.
Next appeal is my
Serial
appeal
number yesterday?
for enhancement.
I know, yes. You have any contention regarding the quantum? Mr. Bill?
Quantum, he was a coolie. According to him, he was earning 10,000 rupees. And the court has taken 8,000 rupees. This accident during 2016.
2016.
9,500. And 10% rightly added. 1/4 deducted.
Yes.
For dependent.
Interest
Income
we
on
have
the
the ground 8%. Interest has to be reduced because their appeal is there.
Conventional rates.
Now, that we will consider in terms of the Supreme Court. Yes. Tell. Yes, consider. So and so learned counsel appearing for. That you give that your WS. WS. Their complaint itself shows they don't know that number. That's even that is supported by that evidence of that owner. He himself said, after that accident, I ran away. There is no chance of identifying that vehicle.
Normally.
Son is not a witness. ಅವರು ಆಕ್ಸಿಡೆಂಟ್ ಆದರೂ ತೀರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ. ಅಲ್ಲ, ಅವ್ರು ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಅಂದ್ರೆ, ಐ ಡೋಂಟ್ ನೋ ದಟ್ ವೆನ್ ವಾಟ್ ಇಸ್ ದ ಕಂಪ್ಲೇಂಟ್ ಹಿ ಹ್ಯಾಸ್ ಗಿವನ್ ದಟ್ ಹಿ ಹ್ಯಾಸ್ ಸ್ಟೇಟೆಡ್.
FIR ರಿಜಿಸ್ಟರ್ ಆದ ತಕ್ಷಣ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬಿಡ್ತದೆ. ಅದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡೋದು ಹೆಂಗ್ ಮಾಡ್ತಾರೆ?
ಎಸ್. So and so learned counsel appearing for. Insurance company has contended that the offending vehicle bearing registration bus bearing registration number KA51C3988 is not involved in that accident. The claimants colluded with the police has implicated that offending bus bearing registration number KA51C3988. He contended that accident has occurred on 12/5/2016 at 6:30 PM. Who is the complainant?
Son of the deceased.
Yes. The second claimant, Prasann Kumar. Yes, the second claimant has lodged the complaint on 13/5/2016. As per that complaint, the vehicle number has been mentioned unknown. On the basis of that complaint, FIR has been registered as per exhibit P1. In that FIR also, vehicle number is not mentioned. It is shown as unknown vehicle. Yes. Even exhibit P7, it has shown that unknown vehicle. He further contended that first time the vehicle number has been mentioned in the charge sheet. The investigation officer has been examined as RW1. In his evidence, he has deposed that on 13/5/2016, the driver of the offending vehicle, one Sri Raju, has surrendered to the police at 1 o'clock. And he has admitted that accident. But Raju has been examined as Madilva. But in the 162 statement recorded by the police, in that Raju has given a statement that he has surrendered in the morning. There is a contradictory in the evidence of RW1 investigation officer and that driver of the offending vehicle. Therefore, he contended that the police has colluded with the claimants, has falsely implicated the vehicle, offending vehicle. He further contended that the tribunal, on the basis of only on the basis of charge sheet filed by he further contended that police has conducted an further contended as per that IME report exhibit P4, it has been conducted in early morning 6:30 AM. It is unusual that police has conducted an IME report in the early morning. Therefore, it is very clear that the police and that owner of the vehicle and the claimants are colluded to make a false claim. He further contended that the trial court, the tribunal, only on the basis of the charge sheet has held that driver of the offending vehicle is negligent in causing that accident. Which is that you have relied on charge sheet, you had really? Charge sheet in support of his contention, 1994, ACJ 1303. Yes. He further contended that even for the sake of the argument, assuming that offending vehicle was involved in the accident, unless it is proved that the driver of the vehicle is negligent, the liability cannot be fixed on that insurance company. In support of this, he has relied on 2014 AR SCW 1081. Therefore, he sought for dismissal of the appeal, allowing that appeal filed by insurance company by dismissing that appeal filed by the claimant. Lastly, he has contended that in view of judgment of this court, the interest awarded by the tribunal 8% is on higher side. Shri Gurudev Prasad, Learned Counsel appearing for insurance company, the claimant has contended that the accident is occurred on 12/5/2016. Due to that accident, the Krishna Reddy has died in the spot.
On the way to the hospital.
The Krishna Reddy has died the way to that hospital. The complainant is not an eyewitness. Immediately after that accident, the driver of the offending vehicle was ran away with that vehicle. He has not stopped that vehicle. Therefore, nobody has noted down that vehicle number. The claimant number 2 has lodged a complaint on 13/5/2016 in the morning as unknown vehicle. On that basis, FIR has been registered. Therefore, just because FIR has been registered as an unknown vehicle, it cannot be contended that offending vehicle has been implicated. Secondly, he has contended that on 13/5/2016, the driver of the offending vehicle himself has surrendered with the police, and he has admitted that since in the accident spot the public has gathered, because of that he has run away and surrendered before the police. In the statement of the driver of the offending vehicle in 162 statement, he has stated that he has surrendered in the morning. No time has been mentioned. Investigation officer in a cross examination, he has stated that on 13/5/2016, 1 o'clock, the driver has surrendered. Therefore, non-mentioning of the time in the statement of Raju will not vitiate that investigation conducted by the police. He further contended that the police, after thorough investigation, has filed a charge sheet. Investigation officer has been examined. No work has been examined as RW1, and the police, along with the charge sheet, has furnished the statement of Raju recorded under section 162 of CRPC. The driver has admitted that accident. 162 statement recorded by the police can be considered as a 166 statement. The admission of the driver of the vehicle become a piece of substantive evidence. Considering these aspects, trial court has rightly held that the offending vehicle bus number so and so as involved in the accident. He further contended that the trial court, after considering that evidence of PW1, RW1 and FIR, sketch, spot major, IME report, charge sheet, has come to the conclusion that driver of the offending vehicle was negligent in causing that accident. The finding is not only on the basis of the charge sheet. Hence, he contended that the appeal filed by the insurance company has to dismiss. In respect of quantum, he contended that at the time of the accident, deceased was
50 years.
earning sum of rupees 10,000 as a agriculture coolie. The tribunal has assessed ಎಷ್ಟು national income ತಗೊಂಡಿದ್ದಾರೆ
8,000 ತಗೊಂಡು
8,000 per month is on lawyer side. Future prospects ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ 10% ತಗೊಂಡು.
Yes. Lastly, he has contended that in view of judgment of apex court in case of magma, claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. Heard the learned counsel for the parties peruse judgment and award and original records. The specific case of the claimants that on 12/5/2016 at about 6:30 PM, deceased G. Krishna Reddy was walking on the extreme left side of the ring road, Bhadrappa layout flavor, Hebbal, Bangalore. At that time, Ishar mini bus bearing registration number KA 51 C 3988 came with high speed and rash and negligent manner, so as to endanger to the life and dashed against the deceased, result of which Krishna Reddy fell down, sustained grievous injury and succumbed to that injury on the way to the hospital. To prove the case, first claimant has been examined as PW1. She has reiterated the statement made in the claim petition, standard of proof according. The accident was occurred on 12/5/2016 at about 6:30 PM. The driver of the offending vehicle, in his 162 statement, he has admitted that he has, after the accident, he has not stopped the vehicle. He has ran away from the spot with that vehicle, along with that vehicle. And he has also admitted that he has surrendered before the police on 13/5/2016 morning. His statement has been produced as exhibit R3. Exhibit R3.
ಅವನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ R1 ಅಂತ.
ಅಲ್ಲ ಅವರು ಇವಂದು ಡ್ರೈವರ್ದು.
ಡ್ರೈವರ್ R1.
163 statement R1. Yes, has been produced as exhibit R1. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಒಂದು ಅವನದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಮುಂಚೆ ಇದನ್ನ ಹೇಳಿದ್ನ FIR has been registered on yes. He's ran away. The second claimant, son of the deceased, has lodged the complaint on 13/5/2016 morning as an unknown vehicle. Immediately, the FIR has been registered as per Exhibit P1. Against unknown vehicle. ಆಮೇಲೆ on statement. It has been produced as Exhibit R1. Immediately after, the police the police, after thorough investigation, has filed a charge sheet. The investigation officer has been examined as RW1. He has clearly deposed that while drawing the major, one Mr. Manjunath has given a statement about the involvement of the offending vehicle. After that, she made thorough investigation and filed the charge sheet. Statement of Manjunath has been produced as R3. R3 could R3. Exhibit R. The Manjunath is the eyewitness. In R3, he has categorically stated that immediately after the accident, the driver of the offending vehicle, along with that vehicle, he has ran away. On basis of all this, ran away. The police also, on the basis of all these records, the police has filed a charge sheet. Even considering that IMA report, FIR, spot case, charge sheet, the tribunal has rightly come to the conclusion that the bus bearing registration number KA 51C 3988 as involved in the accident. The accident is occurred due to the negligence of driver of the bus. Next para. The contention of the counsel for the insurance company that The police has conducted an inspection of the vehicle and prepared the IME report in the early morning. It is unusual. There is no bar under the law to conduct an inspection of the vehicle by RTO officer in the early morning. Even the contention of the insurance company that on the basis of the charge sheet, the tribunal cannot, the tribunal, the contention of the insurance company, counsel for the insurance company that tribunal cannot rely on the charge sheet and come to the conclusion that offending vehicle was involved in the accident. In this case in hand, the court has come to the conclusion negligence of driver of the bus, not only on the basis of the charge sheet, on other documents and evidence of the parties. Therefore, judgment relied upon by learned counsel for insurance company is not applicable to the facts of the case. The other contention, one more contention which has raised by learned counsel for insurance company that just because the vehicle involved in the accident now the content that merely involvement of the bus can't make respondent liable to pay the compensation unless it is shown that accident was caused by rash and negligent act of the bus driver. In the case in hand, the trial court has, the tribunal has come to the conclusion that driver of the offending vehicle on the basis of statement of investigation officer and driver himself has admitted that statement of the driver has been recorded and he was admitted the accident. And considering that complaint, charge sheet, FIR and IME report has come to the conclusion that driver of the offending vehicle, the offending driver of the offending vehicle was negligent in causing that accident. Hence, there is no error in finding recorded by the tribunal in respect of issue number 1 and 2. In respect of quantum, even though claimant has claimed that he was earning 10,000 per month, he has not produced any document to establish the same. Under those circumstances, notional income has to be assessed as per the guidelines for the accident occurring 2000. What is the date? 2015. 2015. Notional income has to be considered as 9,000.
9,000.
for loss of estate, 15,000 for funeral expenses. Mother, ಯಾರ್ಯಾರು? This is this thing. What is the finding of the tribunal?
ಇಲ್ಲ ಅವರು 1/4 ಅಂತಾನೆ ಮಾಡಿದ್ರು. More dependence.
Yes.
ಇಲ್ಲ.
What is that, this thing, Mr. Gurudev Prasad?
ಇಲ್ಲ, wife and 2 sons. All of them were residing together.
Now, where is that?
And the father. Father.
We'll see evidence. Major son is not disqualified from claiming that. There is a judgment. Only thing is whether they are dependents or not, evidence has to be looked into. We'll see that evidence of PW1.
RF5 ಅಲ್ಲಿ.
Prior to that accident, my husband was hale and healthy. The death of my husband has caused great sorrow, unfit to family. Discussed loss of estate, loss of love and affection, and the income of my husband due to this accident has caused a severe fever and so on. So, severe accident, I have put my family other expenses I have suffered. We have put the loss in injuries with life, contributed towards the need of welfare. Where is that? She has not stated that claimants are depending upon the income.
Cross examination, page 5.
Page
5 ಅಲ್ಲಿ.
Cross examination ಇದೆಯಾ?
Cross examination.
Page 5. Yes.
ಮಿಡ್ಲ್ ಪೋರ್ಷನ್. ನನ್ನ ಗಂಡ ಜಾರಿ ಬಿದ್ದು ತಲೆ ಗಾಯ ಮಾಡಿಕೊಂಡು ತೀರಿಕೊಂಡಿದ್ದರೆ ಸರಿಯಲ್ಲ. ನನಗೆ 2 ಜನ ಗಂಡು ಮಕ್ಕಳು. ಅವರಿಬ್ಬರಿಗೂ ಮದುವೆ ಆಗಿಲ್ಲ. ಅವರಿಗೆ ಮದುವೆಯಾಗಿ ಆಗಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. 4 ಅರ್ಜಿದಾರರು ನನ್ನ ಗಂಡನ ತಂದೆಯಾಗಿದ್ದಾರೆ. ಅಪಘಾತ ಕಾಲಕ್ಕೆ ನನ್ನ ಗಂಡನಿಗೆ 50 ವರ್ಷ ಆಗಿದೆ ಸರ್. ಅದನ್ನು ತೋರಿಸಿ ಬೇರೆ ಇನ್ನೇನು ಕೇಳಿಲ್ಲ ಅವರು. ನನ್ನ ಗಂಡ ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಿ
ಅದನ್ನು ತೋರಿಸಿ.
ಅಲ್ಲ, ಅವರು ಮದುವೆ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಅವ್ರ ಜೊತೆನಲ್ಲೇ ಇರ್ಬೇಕು.
ರೇಷನ್ ಕಾರ್ಡ್
ನನ್ನ ಮಕ್ಕಳೇ ನನ್ನನ್ನು ಮತ್ತು ನನ್ನ ಗಂಡ ನೋಡಿಕೊಳ್ಳುದು ಹಾಗೂ ನನ್ನ ಗಂಡನ ಆದಾಯದ ಮೇಲೆ.
ಸಂಜೆ ನನ್ನ ಗಂಡ ಮೃತಪಟ್ಟಿದ್ದಾರೆ. ನನ್ನ ಗಂಡ ಜಾರಿ ಬಿದ್ದು ತಲೆಗೆ ಗಾಯ ಮಾಡಿದ್ದು. ನನಗೆ 2 ಜನ ಗಂಡು ಮಕ್ಕಳು. ಇಬ್ಬರಿಗೂ ಮದುವೆ ಆಗಿಲ್ಲ. ಅವರಿಗೆ ಮದುವೆ ಆಗಿ ಮಕ್ಕಳಾಗದೆ
ಅಷ್ಟೇ
ಸರಿಯಲ್ಲ. ನನಗೆ ಅರ್ಜಿದಾರ ನನ್ನ ಗಂಡ ತಂದೆಯಾಗಿದ್ದಾರೆ. ಅಪಘಾತದ ಕಾಲಕ್ಕೆ ನನ್ನ ಗಂಡ 50 ವರ್ಷ ವಯಸ್ಸಾಗಿತ್ತು ಎಂದರೆ ಸರಿ. ಅದನ್ನು ತೋರಿಸಲು ರೇಷನ್ ಕಾರ್ಡ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಗಂಡ, ವೇರ್ ಇಸ್ ದಟ್ ರೇಷನ್ ಕಾರ್ಡ್?
ರೇಷನ್ ಕಾರ್ಡ್ ಕೊಟ್ಟಿದ್ರು.
ವೆದರ್ ಇಟ್ ಈಸ್ ದೇರ್, ದೇ ಆರ್ ಆಲ್ ರಿಸೈಡಿಂಗ್.
ಹೌದು.
Then it's show that ration.
Exhibit sir. P8
contention our Bini. The respond, the claimant's number, all that person's name is there.
ಇಲ್ಲ, ಎಲ್ಲರದ್ದು ಇಲ್ಲ.
ರೇಷನ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
ರೇಷನ್ ಕಾರ್ಡ್ ಅವರು ರೇಷನ್ ಕಾರ್ಡ್ ಒಬ್ಬರದೇನೆ.
ಯಾರ್ದಿದೆ? ವೈಫ್
ಅಲ್ಲ, ಅವ್ರ ಸಜೆಷನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್ ಇಲ್ಲ, ಅವ್ರ ಸಜೆಷನ್ ಇಲ್ಲ.
ಇದೆಯಲ್ರಿ, ವೈಫ್ ಸಣ್ಣ ಇದೆಯಲ್ಲ ರೇಷನ್ ಕಾರ್ಡ್. ಯಾರು? ಯಾವ ಮದರ್ದು?
ಮದರ್ ಅಲ್ಲ, ಫಾದರ್.
ಫಾದರ್ ಸತ್ತೋಗಿರೋದ್ರಿ. ಮದರ್ ಇರ್ಲಿ ಇಲ್ದೇ ಇರ್ಲಿ, ಶಿ ಇಸ್ ಎಂಟೈಟಲ್ ದಟ್. ಅಲ್ಲ, ಇಲ್ಲಿ ವೈಫು ಸಣ್ಣ ದೇ ಆರ್ ಆಲ್ ಲಿವಿಂಗ್ ಟುಗೆದರ್ ಇನ್ ದಟ್ ಸೇಮ್ ಹೌಸ್.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್
ದೇ ಆರ್ ನಾಟ್ ಮ್ಯಾರಿಡ್. ಎಸ್. ಹೆಣ್ಣು ಮಕ್ಕಳಲ್ಲ, ಗಂಡು ಮಕ್ಕಳು ಮೇಜರ್ ಆಗಿ ಮದುವೆ ಆಗಿದ್ರು ಕೂಡ ದೇ ಆರ್ ಎಂಟೈಟಲ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ದಿಸ್ ಕೋರ್ಟ್ ಸೆಡ್.
ಇದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅದೇ.
ಎಸ್, ಅದನ್ನ ಕಂಟೆನ್ಷನ್ ತಾಳಿ ಸಿ, ಅದರಲ್ಲಿ ಬಿನ್ನಿ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ಮಾಡಿ. The claimant number 2 and 3 are the major sons. They are not depending upon the income of the deceased. The tribunal error in deducting 1/4 for personal expenses. ಅದರಲ್ಲಿ ಅವ್ರದ್ದು ಗುರುದೇವ್ ಪ್ರಸಾದ್ Yes, contended that the claimants are depending upon the income of the deceased. Just because they are major, they cannot be denied. And they are all living together in the same residence. To that effect, ration card has been produced as exhibit P8. Exhibit, P8. Ration card ಯಾವ್ದು ಇದೆ ರೀ? Exhibit P8. ಅಲ್ಲಿ tribunal ಈ finding. Tribunal, after considering that evidence of the parties, has rightly held that the claimants are depending upon the income of the deceased and rightly deducted 1/4. Yes. Best ಆಯ್ತು. ಆಯ್ತಾ calculate? Yes. In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma, claimant number 1 is entitled 40,000 for spousal consortium. 2, 3 is entitled 40,000 each for parental consortium. 4 is entitled 40,000 for filial consortium. In view of judgment of this court, the interest granted by the tribunal 8% has to be scaled down to 6%. In view of order dated 5/12/2022, the claimant is not entitled for the interest for a period of 48 days for enhanced compensation amount. Amount in deposit is transferred to the tribunal. Yes, both. Yes.
Serial number 10, Shantaraj K for appellant, A.M. Venkatesh.
Yes. Yes. 1300. Para 20. 58. Yes. Yes.
And disclosures that the petitioner was admitted from the hospital or it is 326 the case is disposed of the petitioner has to Bulmartia, doctor, Sana, industrial, medical and dental hospital, Bolivia, he was diagnosed with the fracture of lower spine, half of 19 years and operation. His open resistance and after. Later on, the patient was discharged from the hospital after surgery. And there is the nature of the number of days patient surgery penetrate. It clear that definitely the petitioner has undergone much great and inconvenience and some compensation has to be awarded to the petitioner and the petitioner is not a particular group, there is a petitioner awarded awarded and this is that in the case and had the petitioner is saying who ranks was as per existing control of 22 and last report as per petitioner is also produced X-ray results as per 55. However, I'm going through the 326 case to disclose that the petitioner has undergone Saubhagya, Doctor, are also furnished as per the available record.
Doctor evidence. What is that doctor said regarding disability?
30% to the face measure, 10% to whole body, 10% less. As for the injury measure, the intention for a rate of 19 days. Disability also have been taken at 30%. And income has taken at 9,000. Stated that he was doing agriculture work after sheep rearing and I moved 20% per month.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು?
10,000 ತಗೊಂಡಿದ್ದಾರೆ. 10% disability ತಗೊಂಡಿದ್ದಾರೆ. ಆಮೇಲೆ ಊರ್ ಸರ್ಟಿಫಿಕೇಟ್ 35 years ಹೋಗ್ತದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಇವರು ಮಲ್ಟಿಪ್ಲೈಯರ್ 15 ಅಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ. 35 ಗೆ 16 ಮಾಡಿರ್ತಾರೆ.
35 years.
35 ಗೆ 16 ಬರುತ್ತೆ. Is it tribunal assessed 10% or doctor has?
Doctor has said, my lord, as per the only opinion of the PW3. Doctor ಹೇಳಿದ್ದಾರೆ.
ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Complaint of inability to close mouth, healing of foot, loss of speech, facial deformity, and numbness in lower lip.
Yes. Loss of income during the later period. Towards convenience. Yes. Yes, Mr.
ಇಲ್ಲ ಆಕ್ಚುಲಿ ಆನರಬಲ್ ಅದಾಲತ್ ಪ್ರಕಾರ 9,000 ತಗೋಬೇಕು ಮೇಲೆ 9 ತಗೊಂಡಿದ್ದಾರೆ 9,500 ತಗೋಬೇಕಾಗಿತ್ತು. ಸಿನ್ಸ್ ಇನ್ಕಮ್ ಇಸ್ ನಾಟ್ ಪ್ರೂವ್ಡ್ ಬೈ ದಿ ಕ್ಲೈಮೆಂಟ್ ಅದ್ ತಗೊಂಡು ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಸ್ವಲ್ಪ ಒಂದು 10,000 rupees ಕೊಡ್ಬೋದು ಮೇಲೆ.
ಅಮ್ಯುನಿಟೀಸ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಅಮ್ಯುನಿಟೀಸ್
ಕೊಟ್ಟಿದ್ದಾರೆ ಸುಮ್ಮನೆ.
ಫ್ಯೂಚರ್ ಎಕ್ಸ್ಪೆನ್ಸ್
ಪೇಜ್ ನಂಬರ್ 28 ಐಟಮ್ ನಂಬರ್ 5 35,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಲ್ಪ. ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಡಿಸ್ಕಂಫರ್ಟ್ ಫ್ಯೂಚರ್ ಅಮ್ಯುನಿಟೀಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಲೆ. ಅದೊಂದು ಮಾತ್ರ
ಇನ್ಕಮ್ ಡ್ಯೂರಿಂಗ್ ದ ಲೇಟರ್ ಪೀರಿಯಡ್ ಓನ್ಲಿ 1 month has been given.
1 ತಿಂಗಳು ಕೊಟ್ಟಿದ್ದಾರೆ, 2 ತಿಂಗಳಾದ್ರೂ ಕೊಡಿ ಮೇಲೆ. As per the doctor's opinion.
Doctor's evidence they have assessed.
Yes, my lord.
No, that's why I asked whether it is a tribunal or the doctor.
It is
Doctor has
doctor.
not said, I could have. Yes,
Please.
because whole body disabilities only ನಿಮಗೆ ಆರ್ಥೋಪೆಡಿಕಲ್
ಹೌದು.
injuries. Yes. Study. so and so learned counsel appearing for the claimant has contended that due to that accident, claimant has suffered grievous facial injuries. The doctor has assessed disability of 30% to the facial region. Tribunal has assessed whole body disabilities 10% is on the lower side. Secondly, he has contended that at the time of the accident, claimant was earning 20,000 per month. Tribunal has assessed notional income of the claimant as 9,000 per month is on lower side. Lastly, he has contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 17 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, so and so learned counsel appearing for insurance company has contended that claimant has examined the doctor as PW3. Doctor in his evidence, he has deposed that claimant has suffered whole body disabilities 10%. On the basis of the evidence of the doctor, tribunal has assessed whole body disabilities 10%. Even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 9,000 per month. Lastly, he has contended that considering that evidence of doctor and injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Sought for dismissal of the appeal. Heard the learned counsel for the parties peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 25/4/2016 due to rash and negligent driving of rider of motorcycle bearing registration number AA 64J5617. Due to that accident, claimant has suffered the following injury. He has examined the doctor Gopal Krishna as PW3. In his evidence, he has deposed that the claimant has suffered partial disability of 30% of facial region and 10% to the whole body. Considering that evidence of doctor and injury suffered by the claimant, tribunal has rightly assessed whole body disabilities 10%. Even though claimant has claimed that he was earning 20,000 per month, no document has been produced. Under the circumstances, notional income has to be assessed as per the guidelines for the accident occurring in 2016. Notional income has to be considered as 9,500. The multiplier applicable to that age group 35 is 16. Accordingly, loss of future earning has been reassessed as follows.
9,500 into 12 into 16 into 10%, 1,82,400.
Due to that accident, claimant has suffered the following injury. He was inpatient for a period of 17 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 40,000 to 65,000. Loss of amenities has to be enhanced from 35,000 to 50,000. Loss of income during the later period has to be enhanced for 3 months. The compensation awarded by the tribunal in the other hand are just and reasonable. Yes, accordingly, the appeal is allowed in part.
Serial number 11, Ravi Shankar Shastri G for appellant, MU Poonacha.
Yes.
Third respondent.
Yes.
Future medical expenses, in previous case, there is future medical expenses, no interest to be one.
ಅದ್ ನಾವೇನ್ ಎನಾನ್ಸ್ ಮಾಡಿಲ್ಲ. Whatever there in the tribunal, it will be continued. Yes. Now enhance ಮಾಡಿದ್ರೆ ಮಾತ್ರ we have to say that there it will not carry interest. Yes. Yes.
I appear for the third respondent.
Yes. Hmm. Hmm.
Date of accident was 27/5/2016.
2016. Hmm.
Is treated by the claimant for that was 38 years.
Hmm.
It was working as a existing working after this 20% of the period.
Hmm.
Intensity when awarding the loss of independence is 76,000 per month. It fails to consider the future prospects. The age of the deceased was taken as 41 years.
Now that income has taken 6,000. Date of
How-
accident 2016. 9,500.
9,500.
What is that age? What is that, how the tribunal has come to that age? Where is that discussion?
Age of the deceased is taken as 19 years.
Yes, yes. Hmm.
It is mentioned in this document that accident took place on 27/5. Therefore, it is mentioned here and this
What is wrong in that?
our legal case was that was 38 years. So kindly to expect the postmortem report.
Postmortem report will be considered if there is no documents is there.
Your postmortem
Hmm.
speaks that he was 38 years.
Hmm.
And ration card was produced as per CH-10.
Hmm.
Should be then was issued during year 2014. That is on 28/8/2014. Accident in year 2016.
Yes.
This ration card also shows that as on the date of issuance of this ration card, namely on 28/8/2014.
Hmm.
This date was 27. Therefore, 39 years.
What is that other than that documents?
Other than
Hmm.
as to 1/1/79, approximately 8%. Court below relies upon the election ID card instead of this. Postmortem report and
Postmortem report ನಿಮ್ ಎಲೆಕ್ಷನ್ ID ಕಾರ್ಡು ಬೇರೆ ಯಾವ್ದು ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮಾತ್ರ. But if there is any documents, it cannot be relied upon.
Interestingly, because you want space forward in evidence, you
ಆಧಾರ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ ಏನಿದೆ?
other card
ಇದೆಯಲ್ಲ, ಇದ್ಯಾರ್ದಿದೆ ಆಧಾರ್ ಕಾರ್ಡ್?
dependence. Father.
Shiva Pujari is. Where is that Aadhaar card of that deceased? If that is the case, you produce Aadhaar card or any other documents. Then we will catch. This is election commission. Election card is that authenticated documents.
Interestingly, when Peter Jones says this is what they take place. Not even a suggestion that more than that. Not even a suggestion.
There need not be, because when there is an authenticated records are there, they need not put any question at all. Yes. Then future prospects has given.
No, future prospects not given and convention rate also.
41 ಅಂತಂದ್ರೆ 25%. Then you have to produce that any other card by as an additional documents. If you want to produce, I will grant time. Yes.
Convention rate.
Yes, Mr. Punach, you have any
Yes,
submission?
madam. In the absence of
any proof with regard to income,
Yes.
notional income has to be considered, but the accident pertaining to the year 2016,
Yes.
on that regard, 9,500 has to be considered.
Yes, so and so learned council appearing. Ration card? No, that, this election ID card, this is an
Election
authenticated
ID card is
document that is produced by you. Your
the
records.
admitted document produced by the
Still,
petitioner.
if you want that there is a two contradictory, you can still have a chance if you want to produce any other documents. Has he entered in a school? Yes, third. I will just take your submission. Contended that as on the date of the accident, deceased was earning 20,000 per month. Tribunal has assessed notional income of the deceased as 6,000 per month is on lower side. He further contended that as per that evidence of PW1, at the date of the accident, at the time of the accident, deceased was aged about 38 years. Even the ration card produced by Exhibit P10 shows that age of the deceased is 38 years. 37 years. Yes. And that postmortem report has also says he was aged about 38 years. Huh? The tribunal error in relying on that voter's ID card and come to the conclusion that age of the deceased is 41 years. Thirdly, he has contended that in view of judgment of apex court in case of Pranay Sethi, 25% of the income contended that the claimants are entitled for future prospects. Lastly, he has contended that in view of judgment of apex court in case of yes, 24 again. Yes. Future entitled for 40,000 each. Hence, he sought for enhancement of compensation. For contra, Shri Punacha Learned Council appearing for insurance company has contended that even though claimant has claimed that deceased was earning 20,000 per month, they have not produced any document to establish the same. The tribunal has rightly assessed the notional income as 6,000. Secondly, he has contended that the claimant himself has produced that voter ID card. It is an authenticated document issued by Election Commission of India. On that basis, tribunal has rightly assessed age of the deceased as 41 years. Lastly, he has contended that considering that age and avocation of the deceased, overall compensation awarded by the tribunal is just and reasonable. Heard the Learned Council for the parties, peruse judgment and award and original records. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 27/5/2016 due to rash and negligent driving of driver of car bearing registration number KA20B7011. Even though claimant has claimed that he was earning 20,000 per month, even though claimant has contended that deceased was earning 20,000 per month, they have not produced any document to establish the same. Under those circumstances, notional income has to be assessed as per the guidelines for 2016, 9,500 has to be considered. The claimant himself has produced voter ID card issued by Election Commission of India. This is an authenticated document. As per that voter ID card, the age of the deceased as on the date of the accident is 41. Tribunal has rightly assessed that age of the deceased as 41. What is that detection? Bachelor?
Awesome, bachelor. Claimants are parents and sister.
Yes. In view of judgment of apex court in case of Pranayaseti, 25% of the income of the deceased has to be added for future prospects. Since deceased was a bachelor, 50% has to be deducted for personal expenses. The multiplier applicable to that age group is 14. Accordingly, loss of dependency has been reassessed as follows.
9,500 plus 2,375 at the rate of 25%, 11,875 minus 5,937 at the rate of 50%, 5,938. 5,938 into 12 into 14, 9,97,584.
In addition, 15,000 loss of estate, 15,000 for funeral expenses. ಇದೇನು 75-25 ಮಾಡಿದಾರಲ್ಲ ಏನದು? ಓ ಅದು ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಇದಾ?
ಅವರಿಗೆ claimants ಗೆ.
ಲಯಬಿಲಿಟಿ ಏನು ಇದೆ?
ಇಲ್ಲ ಇಲ್ಲ.
In view of judgment of apex court in case of Magma, the first claimant, who is that first claimant?
Father,
Second,
mother and sister.
ಮೂರನೇ sister.
ಹೌದು.
1 and 2 are entitled 40,000 each for filial parental consortium. ಅಲ್ಲ ಮಗ ಸತ್ತೋಗಿರೋದಲ್ಲ?
ಹೌದು.
Yes. 40. This is sister.
Sister. Filial.
Yes.
ಸಂತೋಷ.
Filial consortium 40,000 each for 1 and 2 mother. Yes. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows.
Serial number 12, Suresham Lathur for appellant, connected matter, Nagaraja K.
My lord, I appear for the appellant KSRTC in the connected matter. My lord, the matter could be disposed of. My lord, your lordship may kindly see the MFA number 8425 of 2018. My lord,
Wait, Mr. Nagaraj.
yes,
They
ma'am.
want time. They want time. They are not ready.
ಮುಗಿಯುತ್ತೆ ಸ್ವಾಮಿ, ಏನ್ ಅರ್ಥ ಇದೇನಿಲ್ಲ.
Yeah, yes, madam, what is that? 2 weeks ante. Yes, why your senior is not there? No, he is not well. Yes. At the request of counsel for respondent appellant in MFA 70 of 2019, 15, release this matter after 2 weeks.
Serial number 13, Gurudeva Prasad KT for appellant, Ashok N Patil.
Appearing for the respondent in this.
Yes. Yes, is it only quantum or?
This matter has to be remanded back for the tribunal, my lord. Since the claim petition is dismissed.
No, what is that?
No, my lord, the theft, the thing is that, my lord, the driver, whether the accused is having the driving license or not, that question will come, my lord. And also, my lord, the court has given the finding where admittedly investigation officer has got a right to reopen the C report after secure the rider of the motorcycle bearing registration. If the matter is remanded back to the
Your claimants, how he is responsible?
yes, my lord, but regarding the violation of the terms and conditions of the policy, my lord, whether who is the driver, we have to verify, my lord. If the matter is remanded back, my lord, after it was almost 2017, my lord, the owner of the vehicle has filed the complaint regarding the theft of the vehicle. That will be the way accused will be found, my lord. On that aspect, it will be disposed of in the trial court. Even the quantum also not quantified, my lord. With the directions within 3 months, it may be disposed of. The directions may be issued and send it back to the tribunal, my lord.
Yes. Only
Yes,
on the ground
remanded.
that.
Even I am also seeking the remand also. Even I am also.
The client said that it is only on the basis of the theft vehicle, this has been dismissed. The proposal of the oral evidence.
My lords, may page number 10 of the judgment, my lord.
Yes. Now that you have also no objection for remand,
Yes, ma'am.
then I will by
Let the
consent.
matter paper come.
Yes. So and so learned counsel appearing for the claimant has contended that the tribunal has dismissed that petition only on the ground that ಏನಾಗಿತ್ತು ಏನು ಬೇರೆ
Injuries.
ಅಲ್ಲ ಏನು ಹೊಡೆದ್ಬಿಟ್ಟು ವೆಹಿಕಲ್ ಮಾಡಿದ್ರೆ ಏನು ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. That liabilities is there. Yes. Yes, dismissed only on the ground that offending.
Page number 10, my lord, from the bottom to 10th line, my lord, where it is admittedly investigation officer.
Yes. Allegation that motorcycle, therefore, the rider security investigation officer proceeded according to process administrator. Dismissed, not maintainable anta bardidaರೆ. How it is can be, yes. Only dismissed on the ground that the owner of the offending vehicle was lodged in a complaint that vehicle was theft. Since on that ground alone that claim petition has been dismissed as not maintainable. This is contrary to provisions of section 166 of Motor Vehicles Act. Learned counsel appearing for insurance company has contended that let the matter may be remanded, liberty to remanded with a direction to reconsider that matter afresh in respect of all the issues raised by that parties.
Yes.
In view of the above MFA is allowed, the matter is remitted back to the tribunal with a direction to reconsider that matter afresh. After giving an opportunity to both the parties, all the contentions of the parties are left out.
Serial number 14 adjourned, serial number 15 B.M. Mohan Kumar for
One
appellant.
submission, my lord. The learned counsel for the insurance company, it is.
Badwa? Ad bada. She contended that since offending vehicle, there was already in a complaint that vehicle was theft. On that ground, the tribunal has rightly dismissed that claim petition. Yes.
Serial number 14 adjourned, serial number 15 B.M. Mohan Kumar for appellant. Ravi Kumar N.R. Janardhan Reddy.
Records is required.
Records
is required.
Office is.
ಇಲ್ಲ ಅದಲ್ಲ ಇದಲ್ಲ ಇದಲ್ಲ
ಆಯ್ತು ರೆಕಾರ್ಡ್ ಬರ್ಲಿ ಬಿಡಿ. Records.
I'm for the owner. I'm for the owner. Only the thing is the fresh vehicle that the TC temporary registration number.
Temporary registration number ಕೊಟ್ಟಿದ್ದಾರೆ, permanent number ಕೊಟ್ಟಿದ್ದಾರೆ. ಈ ಮಿಸ್ಟೇಕ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಅಬ್ಸರ್ವ್ಡ್ ದಟ್ ಮೆಲಡಿ ಎರಡೆರಡು ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ ಹೇಳಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ. ಗೋ ಬ್ಯಾಕ್ ಅಂಡ್ ಟು
ಹೋಗ್ಬೇಕಂದ್ರೆ
ಇವರೇ ಮಾಡಿದ್ರೆ
ಅಲ್ಲ ಇವ್ರ ಕನ್ಸರ್ನ್ ಕೊಟ್ರೆ ಅಲೋ ಮಾಡ್ಬೋದಲ್ವಾ?
ನೀಡ್ತಿರೋದು ನೀವೆರಡನ್ನು ತಂದು ಹಾಕಿದ್ರೆ ಆಗತ್ತೆ.
ಅಲ್ಲ ಈಗ
ಟೆಂಪರರಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಅಂದ್ರೆ ಪರ್ಮನೆಂಟ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಎರಡನ್ನು ತಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಎರಡಕ್ಕೂ ಒಂದೇ ನಂಬರ್ ಇರುತ್ತೆ. ಅದನ್ನ ತಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬಿಟ್ಟು ಇವ್ರು ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ರೆ
that this is vehicle is not insured. Then what is that problem with that owner?
No, my lord, what has happened in this case, my lord, earlier the vehicle was registered. Immediately temporary registration was given. Subsequently, they have obtained permanent registration also, but while giving a complaint in the FIR,
they have given that temporary
registration. It is the duty of the owner of the vehicle to produce the temporary registration and the permanent registration, both are same. ಅದನ್ನ ಮಾಡಿಲ್ಲ ಅವ್ರು ಅಷ್ಟೇ.
ಅದ್ರಲ್ಲಿ ರಿಜೆಕ್ಟ್
ಮಾಡಿದ್ರೆ ಏನಂತ ಹೇಳಿದ್ರೆ ಅದ್ರಲ್ಲಿ
ಎರಡೆರಡು ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು, ಅಲ್ಲೊಂದು ಇಲ್ಲೊಂದು ನಂಬರ್ ಕೊಡ್ತಾ ಇದ್ದೀರಿ, ನಿಮ್ಮನ್ನ ನಂಬಕ್ ಆಗ್ತಿಲ್ಲ.
ಇಲ್ಲ ವೆಹಿಕಲ್ ಅಲ್ಲಿ ಪೊಲೀಸರು ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಫೋಟೋ ತಿಕ್ಕೊಂಡಿದ್ದಾರೆ, ಅದ್ರಲ್ಲಿ TC ಅಂತ ಇದೆ. TC ಅಂದ್ರೆ ಅವರು ಟೆಂಪರರಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಅಂತ. ಆ ವೆಹಿಕಲ್ದು ಶೋರೂಮ್ ಇಂದ ಹೊರಗಡೆ ಕೊಟ್ಟಾಗ ಅವ್ರದ್ದು ಶೋರೂಮ್ ಇಂದ ಒಂದು ನಂಬರ್ ಇರುತ್ತೆ, ಟ್ರೇಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ನಂಬರ್, ಟ್ರೇಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ನಂಬರ್ನೇ ಅವ್ರು ರಿಜಿಸ್ಟ್ರೇಷನ್ FIR ನಲ್ಲಿ ಪೊಲೀಸ್ ಅವರು ಇದ್ ಮಾಡಿದ್ದಾರೆ. ಆಮೇಲೆ ಅವ್ರನ್ನ ಓನರ್ನ ಇವ್ರನ್ನ ಕಂಪನಿಯವ್ರನ್ನ ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬಿಟ್ಟು ಹೇಳಿದ್ದಾರೆ, ಈ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಟೆಂಪರರಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ನಂಬರ್ ಇದು ಅಂತ ಹೇಳಿ ಅದಕ್ಕೋಸ್ಕರ ಟ್ರಯಲ್ ಕೊಟ್ಟರು ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ 2 ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
That's what ನೀವು ಎರಡು ಏನು ಕೆಲಸ ಇಲ್ಲ.
If
ಟೆಂಪರರಿ
we have any
ರಿಜಿಸ್ಟ್ರೇಷನ್
ba-
ಮತ್ತೆ
ba-
RC ಎರಡನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬಿಡುತ್ತೆ ಮ್ಯಾಟ್ ರೈಟ್ಸ್.
ಹೌದು
ಅದ್ ಮಾಡ್ಬೇಕಿತ್ತು ನೀವು ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ಅವರು
We'll send it back.
ರಿಮ್ಯಾಂಡ್
Yes, Mr.
ಮಾಡ್ತಾರೆ ನೀನಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್
Yes.
ಮಾಡಿ ಮುಗಿದೋಯ್ತು.
ಆಯ್ತು.
Learned counsel for.
ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ವಿ.
Appellant has contended that. The claim petition has been dismissed only on the ground that
ಬಂದಿರು
ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಮುಗಿದೋಯ್ತಲ್ಲ.
the registration number given in that complaint is different. One from the original registration number. He further contended that, in fact, in the complaint number which is given is temporary registration number.
trade certificate.
Or it's a trade certificate number. Yes, trade certificate number issued to the dealer. At the time of the accident, the vehicle has been registered with a competent authority and that has not been considered by the trial court. In view of the above, the matter requires to be remitted back to the trial court. Accordingly, the appeal is allowed. The judgment and award passed by the tribunal is set aside. Matter is sent it back to the tribunal
Liberty
with a direction to that reconsider that matter afresh in accordance with law. After giving an opportunity to all the parties, all the contentions of the parties are left out.
Serial number 16, Kavita HC for appellant, D. Vijay Kumar.
My lord, I am for the respondent, my lord.
Yes, Mr. Only quantum.
Yes, my lord, death case.
35 years, ಎಷ್ಟು ನಿಮ್ದು ಇದು ಇನ್ಕಮ್ ಕ್ಲೈಮ್ ಮಾಡಿದ್ದು ಇನ್ಕಮ್ ಎಷ್ಟು 30,000 ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ವಾಟ್ ಈಸ್ ದಟ್ ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್
2014, my lord, 8,500.
14 ಗೆ ಎಷ್ಟಿದೆ
8,500.
ವಾಟ್ ಈಸ್ ದಟ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರಾ ಕೊಟ್ಟಿದ್ದಾರೆ ದೆನ್ ಡಿಡಕ್ಷನ್ ಎಷ್ಟು
1/4 ಮಾಡಿದ್ದಾರೆ
1/4 6 why 1/4 by the tribunal
my lord, second wife is not entitled for compensation. Second wife
ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಯ್ತಲ್ಲ 1/4
yes, my lord.
yes then who are that claimants? First is the wife already first is the wife.
Yes, my lord.
Second ಮೂರನೇದು ಅವರಿಗಿಲ್ಲ ಇವ್ರು ಫಸ್ಟ್ 40 ಸನ್ ಅವರು ಸೆಕೆಂಡ್ ವೈಫ್ ಬಿಟ್ಟು ಮತ್ತೆಲ್ಲರಿಗೂ 40,000 ಈಚ್. ಎಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟಿದೆ? ಇಂಟ್ರೆಸ್ಟ್ ಎನ್ಹಾನ್ಸ್ಡ್ ಗೆ 6%. ಎಸ್ ಮಿಸ್ಟರ್ ವಿಜಯ್ ಕುಮಾರ್, ದಟ್ಸ್ ಆಲ್.
Please, my lord. Please, my lord.
Disposed of. Yes, disposed of.
Yes, my lord.
Delay. ಎಷ್ಟು ದಿನ ಇದೆ?
Serial number 17, adjourned for orders. Serial number 18, Akarsh Kumar Gowda for petitioner.
Yes. Yes. Week's time is granted to do the needful.
Serial number 19, FS Dabali for appellant, connected matter, Pawan Chandra Shetty H. Yadunandan.
Yes. Who is that impleading the R5, Mr.
Honorable.
In notice awaiting, ala?
my lord.
Yes, awaiting service of notice to R5.
Serial number 20, Nagaraja Reddy D, KV Shyam Prasad for
Yes. Notice to R1 is dispensed. R2, B Pradeep is directed to take notice.
Serial number 21, Narendra Gowda for appellant, B Pradeep.
Non-compliance of the office objection raised on IA 1/22. This is R1. None appear for the appellant. Alla password ಮಾಡಿದ್ದಾರೆ. Yes, password.
Serial number 22, Satyanarayana for appellant, connected matter, KV Mohan Kumar, B Rupesha.
Refusal of the letter received from the third. Session Court Ramnagara extension of the extension time.
ಇದರಲ್ಲಿ ಕೋರ್ಟ್ ವಾಸ್ ಮೈ ಲಾರ್ಡ್ ವೇಕೆಂಟ್ ಫಾರ್ ಅ ಪೀರಿಯಡ್ ಆಫ್ 1 year. ಈಗ ಬಂದಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಫರ್ದರ್ ಒಂದು 7 months ಕೊಟ್ರೆ ಮುಗಿಸ್ಬೋದು. ಯಾಕಂದ್ರೆ ಅಡಿಷನಲ್ ಇಶ್ಯೂ ತುಂಬಾ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. 7 months ಬೇಕಾಗುತ್ತೆ.
Scored by order dated 22 August 2023. Directed the trial court to dispose of that appeal. Within 6 months from the date of appearance of the parties. Office has received a communication from third additional district and session judge Ramnagara seeking extension of the time for the reasons stated in the communication dated 23/7/2024. The further period of 8 months has been extended from today.
Serial number 23, Mohan S. Rangaswamy TR, M. Krishnappa for petitioner.
Yes, steps to be taken for. ಹಾಕಿದ್ದೀರಾ paper publication? Yes, learned counsel for the petitioner. Praise weeks time to file a necessary application for substituted service.
Amendment. Serial number 24, VC Jagannath Ravishankar as per petitioner, government advocate.
No, you are Ravi Shankar. Now that Jagannath is retired. Yes. Yes. Sri Jagannath, learned counsel appearing for petitioner has filed a memo dated 23/2/2023 for retirement from the case. Memo is taken on record. VC Jagannath is permitted to retire from the case. Office is directed to delete his name. Yes. Yes. Learned counsel for the petitioner placed 2 weeks time. Please this matter of 2 weeks.
Serial number 25, Siddhanuru Vishwanatha for petitioner, SV Prakash.
I appear for respondent.
Yes.
But no, steps to be taken in respect of deceased R10.
Which one?
R10 is no more.
Serial number estido?
25 million.
Yes. Steps to be taken for R10.
Please. I appear for respondent.
Yes. Learned counsel for the petitioner press 2 weeks time to do the needful.
Serial number 26, Manjunath DM, AG Shivanna for petitioner.
Steps to be taken in respect of deceased R3. Week's time is granted at the request of petitioner. Office is directed to delete the name of A.G. Shivanna. Oh, who is filing wakalat? Yes, office is directed to Iburdu Esru delete manak. Delete the name of Manjunath T.M. and A.G. Shivanna. Show the name of so and so. At the request of petitioner, leave this matter after 2 weeks.
Serial number 27, M.R. Irremated for petitioner, government advocate.
Yes, Mr. What is this? ಅವರಲ್ಲಿ ಅದೊಂದು ರಿಮೈಂಡ್ ಮಾಡಿದ್ವಲ್ಲ. Serial number? Parties are directed to be appear before the tribunal on 4th September without any further notice. Yes. ಎಷ್ಟಿದೆ?
Serial number 27, M.R. Irremated, government advocate.
Yes, Irremated.
Serial number 28, Prakash T. Abbar for petitioner, government
lords,
advocate. Krutika
Respondent
Raghavan.
number 14. In this matter, we have filed a memo for retirement. Our name may kindly be deleted.
Yes.
In both the matters, we have filed memo for retirement.
Now, who is appearing now? No, that respondent number 14. Have you filed an wakalat? No, in that appeal, in that writ petition, as a petitioner, you have filed it. This also you have filed. Yes, it is there. Wait. First letter retired from the case. Where is
It
your
may kindly be deleted.
Shri Bhaskaran? For respondent number 14 has filed a memo on 16/9/2022 for retirement. Memo is taken on record. C. Bhaskaran, counsel for respondent number 14 is permitted to retire from the case. Office is directed to delete his name. 14 yaru Chandrakant Patil.
Chandrakant Patil.
Ati idea adidu party hesra?
Party ಹೆಸರು Bhaskaran.
Yes. ಈ ತರ Sri Chandrakant Patil, learned counsel approved for respondent number 14, permitted to retire from the case. At the request of, now what is that, Mr.
Interim order may kindly be issued.
Connected
matter for the petitioners.
Connected matter ಅಲ್ಲಿ Chandrakant Patil filed a memo for retirement for the petitioner, permitted to retire. Yes.
In the first matter, my lords, a request for
Connected.
extension of interim.
Wait. ಯಾರಿಗೆ ಕೊಡಿ ಫೈಲ್ ಕೊಡ್ರಿ ಫೈಲ್ ಅಲ್ಲಿ yes 5 to 11 ಅಲ್ಲ Shri KP Bhuvan, learned counsel, submits that he has filed an wakalat for respondent number 5 to 11 in WP 10210 of 2018. Office is directed to show his name for so and so.
Actually, Allapa's name is going.
ಏನೈತೆ Who is Malappa? Yarri Malappa ಅದು? And directed to delete the name of Malappa for R5 to R11. ಅವ್ರದ್ದು ವಕಾಲತ್ತಲ್ಲ. ನಿಮ್ಮನ್ ಬಿಟ್ಬಿಟ್ಟು ನಿಮ್ ಕಲೀಗ್ ಮಲ್ಲಪ್ಪ ಇದಾರೇನ್ರಿ? ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ. ಅವ್ರ ಹೆಸರು ಹಾಕ್ಸ್ಕೊಬಿಟ್ಟಿದಾರ ಅವ್ರು. KP ಭುವನ್ ಎಲ್ಲಿದ್ದಾರೆ ಮಲ್ಲಪ್ಪ? ಮತ್ತೆ ಇಲ್ಲಿ ಹೆಸರು ದೊಡ್ಡದಿರೋದನ್ನ ಬಿಟ್ಬಿಟ್ಟು ಯಾವ್ದೋ ಒಂದ್ ಸಣ್ಣದ್ರ ಆಫೀಸರ್ ಬಾರಿ ಆಟ ಆಡ್ತಾರೆ. ಎಸ್
Yes, that's interim order.
Your Lordship, extension of the interim order in
Okay,
this
sir.
connected
Yeah.
petition, Your Lordship.
Interim order granted earlier is extended till next week of hearing.
Your Lordship, even in the connected matter.
Yes, yes.
Oblige, Your Lordship.
Serial number 29, D. Nagaraj for petitioner, government advocate.
Petition, my lords. I pray for 1 week adjournment.
Yes, at the request of petitioner, week's time is granted to do the needful.
Serial number 30, Harsha R for petitioner, D. Boregowda.
For the petition, Lordship, I'm filing memo for withdrawal, Lord.
Yes.
The petition is infructuous.
Council for the petitioner has filed a memo dated 7/8/2024. Seeking leave of this court to withdraw this petition on the ground that petition has become infectious. Memo dated 7/8/2024 is taken on record. The above petition is dismissed having become infectious.
Great.
Hearing interlocutory application matter, serial number 31, Manjunath ND for appellant, Janardhan Reddy.
ಈಗ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು, ಇದು ನನ್ನ ಮೇಲೆ ಲಯಬಿಲಿಟಿ ಅಬ್ಸಾಲ್ವ್ ಆಗಿದೆ.
ಯಾವ್ದು ICICI ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್ ಏನದು? ಅವ್ರದ್ದು ಇನ್ಶೂರೆನ್ಸ್ ಇದೆಯಾ?
ಅದು ವೆಹಿಕಲ್ ಸೀಸ್ ಮಾಡಿದಾಗ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ, ಅದಕ್ಕೋಸ್ಕರ ಅವರ ಪಾಲಿಸಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಲಯಬಿಲಿಟಿ ಅವ್ರ ಮೇಲೆ ಫಿಕ್ಸ್ ಮಾಡಿ ಅವ್ರ ಕಂಟ್ರೋಲ್ ಅಲ್ಲಿ ಇತ್ತು ಅಂತ ವೆಹಿಕಲ್.
ಅಲ್ಲ ಈಗ ಏನಕ್ಕೆ ನೋಟಿಸ್ ಯಾರಿಗೆ ಹೋಗ್ಬೇಕು?
ICICI ಬ್ಯಾಂಕ್ ಹೋಗ್ಬೇಕು.
ಯಾಕೆ?
ಅವ್ರ ವೆಹಿಕಲ್ ಅವ್ರ ಕಂಟ್ರೋಲ್ ಇತ್ತು. R1 is the owner of the vehicle. R2 ಅವ್ರ ಹೆಸರಲ್ಲಿ ವೆಹಿಕಲ್ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ, ಅವ್ರ ಪಾಲಿಸಿ ರಿನ್ಯೂ
ಹೋಗಿದೆಯಲ್ಲ ಅವ್ರಿಗೆ?
ಹೋಗಿದೆ, ಅದಕ್ಕೆ ಇವ್ರೇನೋ
ಸರ್ಡ್ ನೋಟಿಸ್ ಸರ್ಡ್ ಅವ್ರು ಬಂದಿಲ್ಲ ಅಷ್ಟೇ.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಅದಕ್ಕೆ ನನ್ನ ಮೇಲೆ ಲಯಬಿಲಿಟಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಪಾಸ್ವರ್ಡ್ ಲೆಟ್ ಹಿಮ್ ಕಮ್.
ಅವ್ರು ಬೆಳಗ್ಗೆಯಿಂದ ಎಲ್ಲೂ ಕಾಣಿಸಿಲ್ಲ ಇವತ್ತು.
Let us see. If it is not come, we will see that what password. ಮಧ್ಯಾಹ್ನ ನೋಡಿ.
Serial number 32, Somashekara KM for appellant.
The ICICI Lombard is served 100%. Shivanna's may be directed.
Nagoda is there.
It's a case of death, my lord, only seeking enhancement.
Yes, yes. R1 is served unrepresented. Shivana Goda is directed to take notice. Next week, Mr. Goda. Next week. Ready? Or we'll have it 2:30. You go through that and submission.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ಅವ್ರು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿದ್ದಾರೆ.
Only 8,000 ತಗೊಂಡಿದ್ದಾರೆ, 11,000.
2011 ಆಕ್ಸಿಡೆಂಟ್ 8,000 ತಗೊಂಡಿದ್ದಾರೆ. It should be 11,000.
What is that? You have said 18,000 per month.
18 ಅಂತ ಹೇಳಿ no document has been produced, my lord, and the notional income is 11,000.
Criminal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
8,000
ತಗೊಂಡಿದ್ದಾರೆ.
11 ತಗೊಬೇಕು.
11 ತಗೋ.
ಬ್ಯಾಚುಲರ್.
Then future prospects ಕೊಟ್ಟಿದ್ದಾರೆ.
40% ಆಡ್ ಮಾಡಿದ್ದಾರೆ, ಬಟ್ 8,000 ತಗೊಂಡು 3,000
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್
ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು ಇನ್ ವ್ಯೂ ಆಫ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್.
ಡಿಡಕ್ಷನ್
40% ತಗೋಬೇಕು. ಆಫ್
ಬ್ಯಾಚುಲರಾ?
ಹಾ, ಬ್ಯಾಚ್
ಆಫ್ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, ಆಫ್ ಮಾಡಿದ್ದಾರೆ.
Then what is the multiplier?
26
ವರ್ಷ.
ಅದು ಕರೆಕ್ಟ್ ಇದೆ.
ಕರೆಕ್ಟ್ ಇದೆ.
ಆಮೇಲೆ
ಕನ್ವೆನ್ಷನ್ ಇಟ್ಕೊಂಡು
ಕನ್ವೆನ್ಷನ್ ಎಲ್ಲ ಡೀಲ್.
ಬ್ರದರ್ ಇಲ್ಲ, ತಂದೆ ತಾಯಿ.
ಮದರ್, ತಂದೆ ತಾಯಿ, ಬ್ರದರ್, 3 ಜನ.
ಬ್ರದರ್ ಇಲ್ಲ, ಮದರ್,
ಫಾದರ್,
ಮೂರೇ ಜನ ಇದಾರಲ್ರಿ?
3 ಜನ.
ಹಾ,
ಬ್ಯಾಚುಲರ್ ಇವರು, ಅದರಿಂದ
ತಂದೆ ತಾಯಿ ಇಬ್ರೆ. ಯಾರು ತಂದೆ ತಾಯಿ ಇದ್ರಲ್ಲಿ? ಫಸ್ಟ್ ಸೆಕೆಂಡ್. 1 and 2 are entitled 40 each. Yes, ಇಂಟ್ರೆಸ್ಟ್ ಕರೆಕ್ಟ್ ಇದೆಯಾ?
30,000 ಕೊಡ್ಬೇಕು. ಇದು ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಷನ್ ಅದ.
ಅದನ್ನೇ
ಓಕೆ,
ದಟ್ಸ್ ಆಲ್. ಇಂಟ್ರೆಸ್ಟ್ ಕರೆಕ್ಟ್ ಇದೆ.
ಇಂಟ್ರೆಸ್ಟ್ ಕರೆಕ್ಟ್ ಇದೆ.
6%.
ಎಷ್ಟಿದೆ ಡಿಲೇ?
94 days.
ಡಿಲೇ ಇಸ್ ಕಂಟ್ರೋಲ್.
Serial number 33, Kashinath JD for appellant.
For applicant.
Just Lingaraj.
Lordship, in this case, enhancement amount 15,25,000, but award amount 6,39,000. Lordship, 143 days delay ಇದೆ ಸ್ವಾಮಿ. That time applicant have a serious health issues. She is bedridden for heart attack, Lordship. Kindly allow
Where
the.
is Lingaraj? You are ready?
No, my lord, kindly allow the delay application, my lord, and call for records, my lord.
Why records? Your income is disputed.
Yes,
Pass
my
over,
lord.
let him come. Pass over. 230.
Acha, please.
Serial number 34, Gurudeva Prasad KT for appellant, SS Sri Shaila.
United India Insurance Company ಯಾರದು?
ಶ್ರೀಶೈಲ filed ವಕಾಲತ್.
United India Insurance Company, Srishaila for R3. R2 ಯಾರದು?
R2 owner
Where is Srishaila? You are
30.
appearing for whom? Mr.
ಶ್ರೀಶೈಲ not in station. I am
He is
representing
taking
ಶ್ರೀಶೈಲ.
time.
7 days delay ಇದೆ. Delay may be condoned, my lord.
Yes, there is a delay of 7 days. Peruse that affidavit for the reason delay is controlled. Please this matter next week.
Please.
Serial number 35, Nagaraja Reddy D for appellant, Ravi
I am
S.
representing
Samprati.
Ravi S. Samprati, my lord.
ಕೇಸ್ ಆಫ್ ಡೇಟ್
Dispose of.
9,000 ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಪೇಂಟಿಂಗ್ ವರ್ಕ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. It should be 11,000 for 2017. And lots of the multiplier ಗೆ ತಾಯಿ ಏಜ್ ತಗೊಂಡಿದ್ದಾರೆ, not the deceased. So multiplier has to be changed. The deceased Margnots was 19 years.
20,000 claim ಮಾಡಿದೀರಾ?
Yes, 20,000 claim ಮಾಡಿದ್ದಾರೆ, painting work ಅಂತ ಹೇಳಿ.
2017 accident 11,000 may be considered.
9,000 ತಾಂಡಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ.
11 ಆಗ್ಬೇಕು.
ಹೌದು. ಮಲ್ಟಿಪ್ಲೇಯರ್ ತಾಯಿ ಏಜ್ ತಗೊಂಡು 41 years ಗೆ 14 multiplier ತಗೊಂಡಿದ್ದಾರೆ.
ಮದರ್ ತಾಂಡಿದ್ದಾರಾ?
Please.
What is the age?
19 years.
19
This
years.
is 19 years, 18 multiplier ತಗೊಂಡು. And future prospects ಏನ್ ಕೊಟ್ಟಿಲ್ಲ, that has to be granted.
Yes, so and so learned council. ಮಾಡ್ತೀರಾ ಮದರ್ದು ಏಜ್ ಏನಾದ್ರು in view of the Sarala Varma. Yes. Who are the claimants?
Father, mother and brother.
Father and
Father, mother and brother.
parents, brother. Conventional, my lord.
Only two.
Two
One
men.
and two.
Two men.
And two. What is that interest?
Interest portion, my lord.
6%.
6%.
8 ಕೊಟ್ಟಿದ್ದಾರೆ ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ.
Enhanced compensation, my lord.
6.
Please.
Yes, this.
Serial number 36, FS Dabali for appellant. 35 days.
Again, other side served.
Served 100%.
35 days delay is condoned. Or admit.
Records may be called forward.
ಅದು admit ಮಾಡಿದ್ರೆ records ಬರುತ್ತೆ.
Records.
Serial number 37, Gurudeva Prasad KT for appellant, Geeta Raj.
Yes.
Speak, my lord.
Delay.
Yes.
They may be condoned.
Delay of 33 days in filing an appeal is condoned. Please this matter next week. Yes.
Please.
Serial number 38, Harish Babu KN for appellant, V Pradeep.
Appear for appellant in this case, my lord. 150 days delay is there.
Where is Pradeep? Pass over. Afternoon. Huh?
Please.
Afternoon. Yes. Afternoon.
Serial number 39, P Suresh for appellant.
I'm for appellant, Swami. Swami, ಇದು 13/7 ಗೆ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿ ಜಾಯಿಂಟ್
We'll send it to that Lok Adalat.
Please, my lord.
Yes.
ಪ್ಲೀಸ್.
Refer this matter to Lok Adalat.
ಅದು ಜಾಯಿಂಟ್ ಮೆಮೊನ ಅಲ್ಲ ಜೊತೆಲಿದೆ ರೆಕಾರ್ಡ್.
ಅಲ್ಲಿ ತೋರಿಸಿದ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ.
ಪ್ಲೀಸ್.
Yes.
Serial number 40, adjourn, final hearing matter. Serial number 41, Nagaraja Hegde for appellant, connected matter, Ravish Benny.
For password. Ravish Benny. Password Madhyana 2:30.
Or it may be called next
Next week.
Next week.
Yes.
Tomorrow or day after tomorrow also I'm ready.
Next week. Please this matter next week.
Serial number 42, Gurudeva Prasad KT for appellant, K Suresh.
Suresh, password.
Password ಬೇಡ, next week.
Next week. Yes. None appear for R2. Please this matter next week.
serial number 43, D.
Okay, for the
Nagaraja
appellant.
Reddy for appellant, BC Shivanya
Case
Gowda.
of injury, my lords. My lords, idರಲ್ಲಿ, though my lords, the accident is accepted. The claim was denied, my lords, on the ground that, my lords, medical records are not supported.
Claim petition dismiss ಆಗಿದೆಯಾ?
ಇಲ್ಲ. ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಎರಡು ಇಂಜುರಿ ನಾನು ಡ್ರೈವರ್ ಪಿಲಿಯನ್ ರೈಡರ್ ಎರಡು ಕನೆಕ್ಟ್ ಮಾಡಿ ಅಲೋ ಆಗಿದೆ. ನನಗೆ ಕಾಂಪನ್ಸೇಷನ್ ಡಿನೈ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ ಬಿಕಾಸ್ ಮಿಲರ್ಸ್ ಹ್ಯಾವ್ ನಾಟ್ ಪ್ರೂವ್ಡ್ ದ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಅಂತ ಮೆಡಿಕಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆನ್ ದಿ ಗ್ರೌಂಡ್ ಮಿಲರ್ಸ್ ದಟ್
ಏನು ಇಂಜುರಿ ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ ಅಂತ.
ಇಲ್ಲ
ಇಂಜುರಿ ಪ್ರೂವ್ ಆಗಿಲ್ಲ ಅಂತ
ಅವರು ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್ ಡಿಫರೆಂಟ್ ಹೇಳಿದ್ದಾರೆ.
ಡಿಫರೆಂಟ್ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಸರ್. ಮಿಲರ್ಸ್ ಮೇ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಪೇಜ್ ನಂಬರ್ 50.
ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ he has sustained injury on 4/8. The original
13,
accident
13,
in the connected matter, my lord, they are saying that they were proceeding and they sustained injury. ಅದರಲ್ಲಿ ಅದ್ರ ಪ್ರಕಾರ 37ರಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್. ಇವ್ರಿಗೆ 37ರಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋದಕ್ಕೆ ಯಾವ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡು ಇಲ್ಲ.
ಇದೆ ಇದೆ.
How the accident occurred?
ಇವರು ಟೂ ವೀಲರ್ ನಲ್ಲಿ ಇಬ್ರು ಹೋಗ್ತಾ ಇರ್ತಾರೆ, ರೈಡರ್ ಅಂಡ್ ಪಿಲಿಯನ್ ರೈಡರ್. ಈ ಕಡೆ ಬಂದು
No, that means to say he has suffered an injury somewhere else and he is claiming ಅಂತ.
ಹೌದು.
ಇವನ ಹೆಸರು ಪೊಲೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲೂ ಇಲ್ಲ.
ನಾನೇ ಕಂಪ್ಲೇಂಟ್.
ಅದ್ರಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್ ಅಲ್ಲ, ಮಧ್ಯ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಬಟ್ ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ, ಯಾವ್ದೋ ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್ ಆದೆ ಅಂತ. ಅಲ್ಲೆಲ್ಲೂ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ದೇ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ ಆಫ್ ಪ್ರೀ ಮೆಡ್ ಹಾಸ್ಪಿಟಲ್ ಅನ್ನೋದು ಒಂದು ಹಾಸ್ಪಿಟಲ್. ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ MLC ನಲ್ಲಿ he has sustained injury on 4/8. On that day he has not become. Therefore 30ನೇ ತಾರೀಕು ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋದಕ್ಕೆ there is no document. That is what the court has observed and dismissed the claim.
Yes. Lords, exhibit P1 is the complaint which is filed by me on the date of accident, that is on 37/2007.
ಒಂದೇ ಸಾಕಾಗಲ್ಲ.
ಇಲ್ಲ ಇದೆ ಫರ್ದರ್ ಇದೆ ಮಿಲಾರ್ಡ್ಸ್. ಎಕ್ಸಿಬಿಟ್ P5 wound certificate ಅಲ್ಲಿ ಮಾತ್ರ 4/8 ಅಂತ ಬಂದ್ಬಿಟ್ಟಿದೆ. ಅಟ್ ದ ಫಸ್ಟ್ ಇನ್ಸ್ಟೆನ್ಸ್ ಐ ಹ್ಯಾವ್ ಗಾನ್ ಟು ದ ಹಾಸ್ಪಿಟಲ್, ಎಕ್ಸಿಬಿಟ್ P10 ಅಲ್ಲಿ ಅಲ್ಲೂ 37ಕ್ಕೆ ಇದೆ.
Have you examined that?
Yes, I have examined.
Doctor from
ಹೌದು ಸ್ವಾಮಿ, ಎರಡು ಹಾಸ್ಪಿಟಲ್ ಇಂದಾನು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರು.
ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಹಿಂಗ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
Yes.
Is it mister?
Lords, may kindly see exhibit P1 Lords is the complaint filed by me. Injury ಆಗಿರೋದು ನನಗೆ ಮತ್ತೆ ದ ಪಿಲಿಯನ್ ರೈಡರ್ಗೆ ಕ್ಲೈಮ್ ಅಲೋ ಆಗಿದೆ ಇನ್ ದ ವೆರಿ ಸೇಮ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡಿದ್ವಿ ನಾನೇ.
ಸೆಟ್ಲ್ಮೆಂಟ್ ಕೂಡ ಮಾಡಿ.
The claim connected matter ಅಲ್ಲಿ I have settled the claim before the local adala. There is a document clear. Here there is a discrepancy. Accident 4/8 ಅಂತ ಡಾಕ್ಯುಮೆಂಟ್ ಇರೋದನ್ನ
Lords, may kindly see exhibit P5 Promaddo MLC ನಲ್ಲಿ ಮಾತ್ರ 4/8 ಅಂತ ಬಂದ್ಬಿಟ್ಟಿದೆ. Even in the discharge summary of the very same hospital says Lords have sustained injury on 37. ಇದೊಂದೇ ಒಂದು ಕಾರಣಕ್ಕೆ the trial court has rejected my claim.
ಅಲ್ರಿ
ಸ್ವಾಮಿ,
ತಪ್ಪೆಂಗ್ರಿ ಬರ್ತದೆ.
ಇಲ್ಲ, MLC ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಮಾತ್ರ ತಪ್ಪಾಗಿ ಬರ್ಬಿಟ್ಟಿದ್ದಾರೆ.
MLC ಅವತ್ತಿನ ದಿನ ಅವತ್ತೇ
I have admitted in that hospital on 4/8 only. First at the first instance Lords have admitted Lords in Tanmay hospital. Exhibit P9 may kindly be seen. ಇಬ್ರು ಅಲ್ಲೇ ಅಡ್ಮಿಟ್ ಆಗ್ತೀವಿ ಹೋಗಿ ತನ್ಮಯ ಹಾಸ್ಪಿಟಲ್ ನಲ್ಲಿ.
ಅಲ್ಲಿ ನಿಮ್ದು ಎಂಟ್ರಿ ಇಲ್ವಾ?
ಏನ್ ಸುಮ್ಮನೆ ಇದೆ ಅಲ್ಲಿ MLC ನ ಇವರು ಬೇಡ ಅಂತಾನೆ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ, MLC ಬರ್ದಿಲ್ಲ ಅಂತ ಅವ್ರು ಬರೀ ಪೊಲೀಸ್ ಇಂಟಿಮೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ದೇ ಹ್ಯಾವ್ ಗಿವನ್ ಪೊಲೀಸ್ ಇಂಟಿಮೇಷನ್. ಎಕ್ಸಿಬಿಟ್ P9 may kindly be seen. That is mine, Muhammad Jalil, the petitioner here, appellant herein. Age about 44 years, residing at so and so, came with the history of RTA on 37/2017 at around 4:45 PM near MC Circle, opposite so and so, Magdi Road. He had sustained injuries treated as an outpatient on 37/2017. Subsequently, MLC register procedure initiated in order to obtain the wound certificate, but the patient and their attenders are not willing referring for MLC procedure and even to pay the MLC procedure fees. In police intimation ಕೊಡ್ತಾರೆ ಅವರು ತನ್ಮಯ ಹಾಸ್ಪಿಟಲ್ ನವರೇ.
ಆಯ್ತು, ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲಿದೆ?
ಪ್ಲೀಸ್ ಎಕ್ಸಿಬಿಟ್ ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಎಕ್ಸಿಬಿಟ್ P10. ಕಿಮ್ಸ್ ಹಾಸ್ಪಿಟಲ್ಗೆ ಹೋಗ್ತೀನಿ ಸ್ವಾಮಿ ನೆಕ್ಸ್ಟ್ ಡೇ ನಾನು. ಕಿಮ್ಸ್ ಹಾಸ್ಪಿಟಲ್ ನಲ್ಲೂ ಬರೀತಾರೆ ಎಕ್ಸಿಬಿಟ್ P10 ಮೇ ಕೈಂಡ್ಲಿ ಬಿ. ಅಲ್ಲೂ ಬರೀತಾರೆ ಸ್ವಾಮಿ ಇಂದ 37ಗೆ ರೋಡ್ RTA on 37.
Yes, yellow exhibit P10.
P10 Milords.
This is Kims
Hospital. And Promad Hospital exhibit P10 subclass 2 ನಲ್ಲಿ ಎರಡು ಡಿಸ್ಚಾರ್ಜ್ ಸಮರಿ ಅದರಲ್ಲೂ ಇದೆ. ನಾನು 37ಕ್ಕೆ ಡಿಸ್ಚಾರ್ಜ್.
ಹೆಸರೇನು?
ಮೊಹಮ್ಮದ್ ಜಮೀಲ್ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಹೆಸರು ಇದರಲ್ಲಿ?
ಮೇಲ್ಗಡೆನೆ ಇದೆ ಸ್ವಾಮಿ. ಪೇಷಂಟ್ಸ್ ನೇಮ್ ಫಸ್ಟ್ ಮೊಹಮ್ಮದ್ ಜಮೀಲ್.
RTA and 30th/7
37. ಅಲ್ಲೂ ಕೂಡ I requested for discharge and to take treatment in the some other hospital. Subsequently, my lords have joined in ಇದರಲ್ಲಿ Promed hospital ನಲ್ಲಿ. Next discharge summary, next sheet. ಅದರಲ್ಲೂ ಕೂಡ ಇದೆ. Patient illness ಅಲ್ಲೂ ಬರೀತಾರೆ. RTA on 37/2017 around 4:45 near so and so.
ಆಮೇಲೆ
I have taken treatment in Promed hospital. But in Promed hospital, my lords, while writing ಇದು MLC ಅವರು 4 ಅಂತ ಬರೆದು ಬಿಡುತ್ತೆ. ಆಕ್ಸಿಡೆಂಟ್ ಡೇಟ್ ನ ತಪ್ಪಾಗಿ ಬರೆದು ಬಿಡ್ತಾರೆ. ಎಕ್ಸಿಬಿಟ್ P5 ನಲ್ಲಿ.
ನೀವು ಅಡ್ಮಿಟ್ ಆಗಿದ್ದು ಯಾವತ್ತಲ್ಲಿ?
4th ಗೆನೆ ಸ್ವಾಮಿ. Date of admission 4/8/2017. In exhibit P10 it issues.
Patient 45 minutes pregnancy has gastric discharge to promoters history of RTA. Exhibit P5 అని ಹೇಳೋದು. Exhibit
P5 ನಲ್ಲಿ ತಪ್ಪಾಗಿ ಆಗೋಗಿದೆ ಅಂತ Promed hospitalದು MLC.
ಇದು ಯಾವುದು ಎಕ್ಸಿಬಿಟ್? ಇದು ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿ.
Exhibit P10 ಸ್ವಾಮಿ ಅದು.
Promed hospital exhibit
P10 only.
ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿಲಿ 37 ಇದೆ ರೀ.
ಅದಿದೆ.
ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿ ಇದೆ. Only MLC by mistake they have written.
Remand.
Yes. Yes. So and so. Net council appearing for. Claimant has contended that immediately after the accident, he has lodged a complaint as per exhibit
P1 my lords.
P1. And he has admitted to first ಯಾವ hospital ಗೆ?
Tanmaya hospital, exhibit P9.
Tanmaya hospital, exhibit
P9.
Exhibit P9. In that, petitioner has admitted as an inpatient. Outpatient. In that exhibit P9,
P9 ಅಲ್ಲಿ ಇದೆ.
P9, that it has mentioned that petitioner has suffered an injury in RTA on 30/7/2017. Later, he has
Kims hospital, that's exhibit P10.
Yes, he has admit ಆಗಿದ್ರಲ್ಲಿ.
ಹೌದೌದು. ಅಲ್ಲಿ 2 days
admitted in Kims hospital, exhibit
P10 my lords.
P10. In that also, it is mentioned that date of the accident, he has suffered an injury in road traffic accident on 30/7/2017.
ಅದು P10.
After he has taken a treatment in
Promed
hospital. In discharge summary, in the Promed hospital, it is ಅದೇನ ಅದರಲ್ಲೂ 37 ಅಂತಾನೆ ತೋರಿಸಿದಾರಲ್ಲ.
ಹೌದು. ಬಟ್ MLC ನಲ್ಲಿ ಬರೆಯುವಾಗ 47 ಸರ್.
Promed hospital, in discharge summary, it has shown that claimant has suffered an injury RTA on 30/7/2017. By oversight, in MLC of Promed hospital, it has mentioned that he has suffered an injury on 4/8/2017. The tribunal has not considered that exhibit
P10, P9 and 10.
P9 and P10 and the complaint. Therefore, the matter requires to be remitted back to the tribunal for reconsideration. Accordingly, ಯಾವ್ದು MEC ಇದು?
ಬೆಂಗಳೂರು ಹೆಸರು.
MEC ನಂಬರ್ ಯಾವ್ದು ಇದು?
MEC 4755.
4755/2017. Passed on so and so date is set aside. Matter is sent back to the tribunal for reconsideration of afresh after giving an opportunity to both the parties. All the contentions of the parties are
The
left.
date for appearance may be fixed.
Parties are directed to be appear before. ಇಲ್ಲಿ ಓನರ್ ಯಾರಿದ್ದಾರೆ? ಓನರ್ ದೇನ್ ಲಯಬಿಲಿಟಿ ಅಂಡ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ.
Liability and
ಅದ್ರ ಕನೆಕ್ಟೆಡ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡಿದೀವಿ ನಾವು.
Yes. Parties are directed to be.
ಇದು ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋದ್ರಿಂದ ನಾನು ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ ಇದನ್ನ.
Yes, on 10th September without any further notice.
Serial number 44, Rangegowda NR for appellant, connected matter, D. Vijay Kumar.
Week, my lord. Yes, at the request of petitioner, please this matter next week.
Serial number 45, adjourn. Serial number 46, D. Nagaraja Reddy for appellant.
appellant,
Please.
Lords, idralluno, the second admission was disbelieved by the trial court, lords, on the ground that the treatment was taken later. First admission ಆದಾಗ simple injuries ಅಂತ ಕೊಟ್ಟಿರ್ತಾರೆ. Lords may kindly
Dismiss ಮಾಡಿದಾರ?
ಅಲ್ಲ ಅಲೋ ಆಗಿದೆ.
Allow
ಸೆಕೆಂಡ್
ಮಾಡಿದ್ದಾರೆ.
ಅಡ್ಮಿಷನ್ ಗೆ ಕ್ಲೈಮ್ ಕೊಡ್ಲಿಲ್ಲ. ಸೆಕೆಂಡ್ ಅಡ್ಮಿಷನ್ ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್ ಅದಕ್ಕೆಲ್ಲ
Admitted in
ಕೊಡ್ಲಿಲ್ಲ.
the hospital. Thereafter, my lord, he has discharged. While first admission, the X-ray was taken, wherein there is no fracture. He has discharged from the hospital. Subsequently, he is, according to them, he has taken the treatment where the X-ray was taken. In that, fracture was noticed. Hospital admit ಆಗಿದ್ದಾರೆ, treatment ತಗೊಂಡಿದ್ದಾರೆ, X-ray was taken, there is no fracture.
ಎಷ್ಟ್ ದಿನದ ಮೇಲೆ ಅದು?
21 ದಿನ. ಅದಕ್ಕೆ that was disbelieved.
ಅವ್ರನ್ನ ಡಾಕ್ಟರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದೀರಾ?
ಎಲ್ಲಾರನು ಮಾಡಿದೀವಿ. Lords, in the first hospital, lords, MRI was suggested. ಅಲ್ಲಿ ದುಡ್ಡಿಲ್ಲ ಅಂತ ಹೇಳಿ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟು ತಿರ್ಗಾ 10 ದಿನಕ್ಕೆ MRI ಮಾಡಿಸಿ.
Only thing is that this injury is related to the accident.
Accident or not ಅಂತ.
X-ray ತೆಗ್ದಿದ್ದಾರೆ. X-ray ನಲ್ಲಿ ಬಂದಿಲ್ದೇ ಇರೋ ಫ್ರಾಕ್ಚರ್. ಆಮೇಲೆ ಇವರು
MRI.
ನೀವು ಕೇಳಿದಿರಾ ಕ್ರಾಸ್ ಅಲ್ಲಿ ಡಾಕ್ಟರ್ಗೆ?
ಹೌದೌದು, ಅದನ್ನೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಬ್ಸರ್ವ್ ಮಾಡಿರೋದು. ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದೀರಿ, ಹಾಸ್ಪಿಟಲ್ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದೀರಿ, ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದ್ದೀರಿ, ಅದಾದ್ಮೇಲೆ ಈಗ ಫ್ರಾಕ್ಚರ್ ಆದ್ರೆ ಸ್ವಾಮಿ ಕಾಲು ಊದ್ಕೊಳ್ಳು 15 ದಿನ ಬಿಟ್ಟು ನೀವು ಹಾಸ್ಪಿಟಲ್ ಬೇರೆ ಹಾಸ್ಪಿಟಲ್ ಹೋಗಿ ಆವಾಗ ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ, ದಟ್ ಕೆನಾಟ್ ಬಿ.
ಯಾರು which is the doctor who has treated second time?
PW3 and PW5 are the doctors. Second hospital doctor PW3. First yes, Lords, the date of accident is 9/1/2018.
What is that explanation of the doctor, Mr. Shivana, in cross examination?
ಅವ್ರು
He has stated, Lords, the injuries are 1 month old ಅಂತಾನು ಹೇಳ್ತಾರೆ.
ಅವ್ರು ಅದನ್ನೇ ಹೇಳ್ತಾರೆ, 1 month ಇಷ್ಟೇ ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಅವ್ರು ಹೋಗಿದಾರೆ ಹಾಸ್ಪಿಟ್ಲಿಗೆ, ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ. ಬಟ್ ಏನಂದ್ರೆ ಫಸ್ಟ್ ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್ ಆಗಿ 21 ದಿನ ನೀವು ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡು ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿ, ಡಿಸ್ಚಾರ್ಜ್ ಅಡ್ವೈಸ್, X-ray was taken. ಇಲ್ಲಿ ಕಾಣದೇ ಇರೋ ಫ್ರಾಕ್ಚರ್ ಆಮೇಲೆ ಬಂದಿದೆ ಅಂತ ದೇರ್ ಕಂಟೆನ್ಷನ್.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಡಾಕ್ಟರ್ ನೀವು
ಡಾಕ್ಟರ್ ಏನಿಲ್ಲ, ಡಾಕ್ಟರ್ ಏನು ಇದನ್ನ ರೀಸನ್ ಅಸೈನ್ ಮಾಡಿಲ್ಲ. ನಾವು ಅವ್ರೇನ್ ಹೇಳೋದು ಅಂದ್ರೆ ನಾವು MRI ಹೇಳಿದ್ದು ಅವ್ರು ಮಾಡಿಸ್ಲಿಲ್ಲ, ಈಗ ಮಾಡಿಸಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಅಂತ ಹೇಳಿದ್ರು ನಿಜ. ಬಟ್ X-ray ತೆಗ್ದಿದ್ದಾರೆ, ಅವಾಗಿಲ್ಲ ಫ್ರಾಕ್ಚರ್. ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ 20 ದಿನ ಮೇಲೆ ಒಂದ್ ಫ್ರಾಕ್ಚರ್ ಆದ್ರೆ 20 ದಿನ ಇದ್ರೆ ಕಾಲು ಉಳಿದಿರುತ್ತೆ ಸ್ವಾಮಿ. Therefore the court has.
Have you put this question to that doctor? Please, what is his answer?
ಅದಕ್ಕೆ ಅವ್ರು he has not given any answer.
On the
Lords, kindly ನಾನು ಡೈರೆಕ್ಟ್ ಆಗಿ PW5 ಗೆ ಹೋಗ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ. ಫಸ್ಟ್ ಡಾಕ್ಟರ್, ಫಸ್ಟ್ ಹಾಸ್ಪಿಟಲ್ ಡಾಕ್ಟರ್.
ಫಸ್ಟ್ ಹಾಸ್ಪಿಟಲ್ then dispute ಇಲ್ಲ. ಸೆಕೆಂಡ್ ಡಾಕ್ಟರ್
ಪ್ಲೀಸ್ Lords, PW3 ಅವರು ಹೇಳ್ತಾರೆ 1 month old injuries ಅಂತ ಅವರು ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಡಾಕ್ಟರ್ ಬಾಲಚಂದ್ರ.
No, I am not on that. See, when first X-ray has been taken, where there is no any.
Yes, Lords, there, Lords, MRI was suggested. ಅಲ್ಲಿ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ, MRI ಹೋಗಿ ಅಂತಾರೆ. Because of financial difficulties, he got discharged against the medical advice. ಅದಾದ್ಮೇಲೆ MRI ತೆಗಿಸ್ತಾರೆ 10 ದಿನಕ್ಕೆ. ಅಲ್ಲಿ the injuries were diagnosed. The doctor has clearly stated, Lords, thereafter we have waited for 2 days for getting MRI report, but she has not underwent MRI due to financial difficulties.
Okay, we'll see that afternoon, 2:30.
Please
come back. 2:30. Yes. Serial number 50. No. What do you want, mister? You are appearing for the request of petitioner. Counsel for the petitioner leads this matter next week.
My lord, 48. I am petitioner in second connected matter next week.
Yes, who is in the first matter? Siddharth.
We are for the third contestant.
Yes, he wants time. Any objection, Mr.? Next week. At the request
Date
of
may be
council
given.
for Eastner in 23637 of 2012. Please this matter next week.
ಇದೆ.
ಫೈಲ್ ಹಿಂಗೆ ಇರಲಿ ಸರ್.
Is spot?
ಫಾರ್ಟಿ-ಟು ಅರ್ಜೆಂಟ್ ಮಾಡಿಸ್ಕೊಂಡು ನೀವಿಲ್ಲ ಅದ್ರಲ್ಲಿ
ಅದೇ ನಾನು ಅನ್ಕೊಂಡೆ.
42 ನಿಮ್ದಲ್ಲ.
ಅಂದೆ
42 ಗುರುದೇವ್ ಪ್ರಸಾದ್ ಸುರೇಶ್ ಅಂತಿದೆ.
ಓ ಸಾರಿ ಅದಲ್ಲ ಕರೆಕ್ಟ್ ಸರ್ ಅದು
48 ಇವಾಗ ಅರ್ಜೆಂಟ್.
Court officer.
ಹೇಳಿ ಸರ್ ಯಾರು?
Serial number 2. Serial number 2 ಏನಾಗಿದೆ?
ಪಾಸ್ಪೋರ್ಟ್.
Okay.
Sir, serial number 42 ಏನಾಯ್ತು sir?
The person with no proof of income will be
Voting muted, my lord. Voting muted, my lord.
Serial number 47, Rajaram as per appellant, Sanjay Nair, O Mahesh.
I am for the appellant, my lord.
I appear for second respondent.
Is it one more connected matter?
Yes, my lord. 85, 88, Shivakumar Swami.
Who has filed that?
We
85, my lord, 85, arising out of the same act.
we, in that mean, we are also appellant, my lord.
You are a appellant in that.
Yes, my lord.
Idea. Mahesh, there are one more matter.
Yeah, 85, my lord, 85 of,
This is 85.
88, my lord.
88, my lord, 88.
88. You are ready in that?
I'm ready, my lord, I'm ready.
Because in the cast list it has not shown, but file is there.
Yeah, I'm ready, my lord.
Yes, yes, Mr.
Yes, ma'am. On 2011-2017, about 12:15 p.m., the afternoon when the
85.
claimant along with the brother Shivakumar Swami as a payline reader.
Mr. Counsel.
Yes, my
Now
lord.
this is arising out of MEC number?
MEC number 85, my lord.
No, MEC number, which is that?
MEC number 215 of 2018.
Yes, 215.
215.
Then you come to the 215. Where is the discussion regarding 215? Judgment.
Judgment, my lord.
Para 13. Now you argue
Page number 11.
what are the contention?
Injuries, my lord. The lacerated, wounded over the forehead, tendons, swelling, deformity, cryptos, and abnormal movement over right lower, absorption over right knee, absorption over left elbow, absorption over left side of abdomen. And also the disabilities, my lord. Pain at right thigh and right knee joint, difficulty in right hip movement along with pain, difficulty to
Have you
sit.
examined the doctor?
Yes, my lord.
No doctor examined, my lord.
They also give you 10% disability, my lord.
Where is that discussion of the doctors?
Page number 11, second paragraph, second line.
Yes, read.
Disability arises 10%, my lord.
Yes. What is the doctor said? You read para 14.
The petitioner has alleged that due to the injuries sustained by him in the accident, he has suffered permanent disabilities and he is not able to do his work as earlier. He is facing difficulty to walk and lift weight. Dr. S.C. Krishna, who has treated the petitioner at Sri Chamarajendra Hospital, Hasana, has also deposited that the petitioner Sri Mallikaradhya came to Sri Chamarajendra Hospital with history of road traffic accident on 2011-2017. On his examination, he has suffered fracture injury in his right thigh and has been operated on 23/11/2017 with the implement and is still under follow-up treatment. Further, states that on 10/4/2019, he has clinically examined the petitioner and found the following disabilities. And right knee joint, difficulty in right hip movement along with pain, difficulty to sit cross legs to sit for long time, for walking and climbing stairs. As per X-ray taken, there is slow progress in union bones.
As per the doctor evidence, they have taken a 10.98%.
Disability, madam.
What is the income you have claimed?
Notional income only 7,500, madam.
ನೀವು ಎಷ್ಟು ಕೇಳಿದ್ರಿ?
20,000.
20,000.
20,000. But
ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 7,500.
7,500.
What is the date of the extent?
2017, 2017.
17. Yes. Yes, Mr.
Yes, my lord. They also give further states that there is no satisfactory union of the bones another operator requires. He also assesses the disability the tune of 32.94% of. He has produced case sheet and the X-rays EC.
How many days you are in the hospital?
15 days, my lord, and taken 2 months bed rest.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ?
15,000 only, madam.
Loss of income?
Loss of income?
88,000. Pain and suffering?
15,000.
20,000. Loss of immunities 20,000.
Loss of immunity, not 10,000.
Loss of immunity only 10,000, madam.
Shock 20,000.
Attendance and
Medical
head charges.
Mr. Mahesh will consider that notional income.
But
Disability will assess same as it is.
case of injury, my lord, they have not produced anything to show what was the income.
Yes.
Your kindly see, claims to be, my lord, dairy farming. But nothing has been, my lord, produced.
Yes.
And
You have
division
argued this
bench of-
matter, earlier before any bench.
No, madam. This came up last week in this bench only.
No, some calculation has been made. Why?
Yes, right. Yes, my lord. No, they said they connect the matters only.
No, but this has been argued before any bench, Mr. Mahesh.
And I have not made any notes, my lord, in my file.
No, but in that this thing, there was a calculation and all. No, the bench has calculated instead of 10.98, they calculated 11%.
11%, that is rounded off to 11%.
Yes.
10.98 is rounded off to 11%.
No, that was, there was a calculation in that my records. Therefore, I said, why can't take that as 11,000 they have taken 12 and 9%. Yes. What about that second matter?
That is also a case of injury, my lord.
Second matter.
Second matter.
Shiv Kumar Swami, aged about 50 years. Whole body disability is considered, my lord, at 9.28, age at 57. Future loss of earning capacity 75,168.
Yes.
20,000, my lord, for disability and all that. And 10,000, my lord, for loss of amenities of life.
Yes.
15,000 loss of income.
Yes.
12,000 nourishing food attendance, so on so.
Yes.
Totally, my lord, 1,32,168 with 9% interest in both the appeal, both the claims.
Yes, yes. Yes, Mr. That's all. You have completed your arguments.
Yes, ma'am.
Can I dictate?
Okay, ma'am.
Yes. That's all, Mr. Mahesh.
Yes.
That MEC 215 of 2018. Learned Council for the Climate has contended that due to that accident, Climate has suffered grievous injury. He was inpatient for a period of 15 days. He has examined the doctor. Doctor has assessed the disability 2.94% to the right leg. The tribunal has assessed notional income as 10.98% is on lower side. Secondly, he has contended that at the time of the accident, he was earning 20,000 per month. Tribunal has assessed notional income of the claimant as 7,500 is on lower side. Lastly, he has contended that Due to that extent, claimant has suffered grievous injury. He was inpatient for a period of 15 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Hence, he sought for enhancement of compensation. For contra, Sri O. Mahesh, Learned Counsel appearing for insurance company, has contended that even though the claimant has examined the doctor has assessed the disability for right leg is 32.94%. He has not assessed whole body disabilities. Considering that evidence of doctor and injury suffered by the claimant, tribunal has rightly assessed the whole body disability is 10.98%. In respect of quantum, he has contended that even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 7,500 per month.
My lord, 2017 notional income 11,000, my lord.
Yes.
My further submission is 11% disability, my lord, will not come in the day of running a dairy business.
Yes, but the tribunal has taken that this thing.
9% interest is granted, that's why, my
Yes,
lord, it's a totality of the award is reasonable.
Yes, he further contended that due to that disability, it will not affect his avocation. The tribunal has error in awarding compensation for future loss of income. Lastly, he has contended that considering that evidence of doctor and injury suffered by the claimant, compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is just and reasonable. The interest awarded by the tribunal, 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the Learned Counsel for the parties, Perose, judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 20th/11/2017 due to rash and negligent driving of driver of car bearing registration number KA03 MP 3678. Due to the accident, claimant has suffered the following injury. He has examined the doctor as CW1. In his evidence, he has deposed that claimant has suffered 32.94% disability to right leg. Considering that injury suffered by the claimant and considering that age and avocation of the claimant, I am of the opinion that whole body disabilities has to be assessed 11%. Even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Under the circumstances, notional income has to be assessed as per the guidelines. For the accident occurred in 2015, the notional income has to be considered as
2017, my lord.
2017, 11,000. The multiplier applicable to that age group is 9. Accordingly, loss of future earning has been reassessed as follows.
11,000 into 12 into 9 into 11%, 1,30,680.
Due to the accident, claimant has suffered the following injury. He was inpatient for a period of 15 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for loss of the pain and suffering from 20,000 to 30,000, loss of amenities from 10,000 to 20,000. Loss of income during the later period is granted for 3 months. The compensation granted by the tribunal, in the other hand, are just and reasonable. Enhanced compensation amount carries 6% interest. ಎರಡನೇ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರಿ?
19 days, madam.
19.
19.
ಇದ್ರಲ್ಲಿ ಡಿಸಬಿಲಿಟೀಸ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
9.28%.
9.28. Yes.
9.28.
Yes. See, so and so in MEC 216 of 2018. Learned Council appearing for the claimant has contended that at the time of the accident, he was earning 20,000 per month, working as an agriculturist. The tribunal has assessed notional income of the claimant as 7,500 is on lower side. He further contended that considering that evidence of doctor and injury suffered by the claimant, compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Per contra, Shri Mahesh Learned Council appearing for insurance company has contended that even though claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 7,500. He further contended that the tribunal has assessed whole body disabilities is 9.28%. Due to that disability, it will not affect his avocation. Therefore, compensation awarded by the tribunal towards loss of future income is on higher side. Lastly, he has contended that considering that evidence of doctor and injury suffered by the claimant, compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses, just and reasonable. Interest awarded by the tribunal is on higher side. Hence sought for dismissal of the appeal. Heard the Learned Council for the parties, Perose, judgment and award. It is not in dispute at the same body. Even though claimant has claimed that he was earning 20,000 per month, working as an agriculturist, he has not produced any document to establish the same. Therefore, notional income has to be assessed as per the guidelines. For the accident occurred in 2017, notional income has to be considered as 11,000. The claimant has examined the doctor as CW1. In his evidence, he has deposed that he has suffered 27.83% disability to left leg. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that whole body disabilities has to be assessed 10%. Even though claimant has claimed that income has to be taken as 11,000. At the time of the accident, he was aged about 57 years. Multiplier applicable to the age group is 9. Accordingly, loss of dependent future income is reassessed as follows.
11,000 into 12 into 9 into 10%, 1,18,800.
Due to that accident, claimant has suffered the following injury. He was inpatient for a period of 19 days. Considering that evidence of doctor, I'm inclined to enhance compensation for pain and suffering 20 to 30, immunities 10 from 10 to 20. Other head, just loss of income during the later period for 3 months. Other head, just and reasonable. enhanced compensation amount carries 6% interest. Yes.
Separate judgments, my lord?
Yes.
Like if it is combined, my fee will reduce.
No. It will be separate order, Mister.
Separate, please.
Yeah, because two MF.
Yes.
Serial number 48 adjourned, serial number 49, Gopal for appellant, petitioner, H.N. Basavaraju. Serial number 49, Gopal.
Yes, Mr. Gopal, what is this? You are appearing for?
Respondent R3 and R4.
Who is that Gopal? What is that? Yes. Second respondent, commissioner of division. No, separate. He is a grantee or a purchaser? Purchaser. You are the grantee.
Grantee.
Without permission. Now that, what is that date of grant? 1963. Share.
The number is
91. Application is filed 10. Antandra 19 years.
Yes, sir.
Then that issue is pending now.
That's
That limitation.
sir.
He has filed an appeal on the grounds of Supreme Court judgment. He has filed a writ on the basis of the Supreme Court judgment that your application is beyond limitation. Now you have an advantage of amendment. Now that has been questioned now.
Sir, a week's time may be granted. I will inquire senior counsel.
Yes. None appear for petitioner. Reach this matter after 2 weeks.
Serial number 50 adjourned, passed over matter, serial number 2, Avani Tukshi for petitioner, V.D. Raviraj.
Appear for the petitioner, my lord. This is the matter in which, my lord, the second wife has filed an application against the OS against the first wife, my lord. I've sought transfer from Chikmagalur to Mysore. I informed the opposite party. I think he's online, my lord. My lord, my lordship had asked me on what basis I'm seeking transfer, my lord. In fact, the submission is that the 4 plaintiffs, who are the 4 respondents herein, they're in fact not actually living in Chikmagalur. My lordship had asked me to produce certain documents. I'm filing, my lord, a memo. My lord, the first document pertains to,
Have you served a copy to other side?
my lord, I've brought a physical copy.
You serve a copy?
No, my lord. I have not received any copy.
You have not received. You serve it and file it in that counter.
Please, my lord.
Yes.
It is the first respondent is it is the suit for injunction, my lord.
It's a
They
bad
are asking
injunction,
for.
sir.
They are
for
the
injunction.
4.
Bad injunction, my lord.
Now that you are the plaintiff.
I am the all the 4 are plaintiffs. All the 4
plaintiff.
respondents are the plaintiff.
Yes. Suit for declare.
Bad injunction, please.
Where is the property situated?
It's in Chikmagalur.
Then
Not to interfere with my question insofar as the residential house is concerned. She
Yes.
claims to be the first wife of my husband.
Yes.
So she filed she tried to interfere with my possession over the social property. I along with my sisters filed a suit for injunction.
Yes.
Now they want this injunction suit to be transferred to the Mysore. All the 4 other 3 respondents are also female members of the family, and all are having children.
My lord, my submission is that the respondents are not actually living in Chikmagalur anymore. In fact, in the domestic violence case, the address is served as I left the address, my lord. So they are no longer living in Chikmagalur. In fact, I'm producing the documents to show they are in Bangalore, my lord. So the respondent number 4 as well as the respondent number 1 is living with the husband in Bangalore. In that view of the matter, my lord, even Bangalore or Mysore, for her, it's very difficult to travel to Chikmagalur is the only difficulty.
No, even then they are also women. They have to difficulty for them to travel.
My lord, in fact, they're not in Chikmagalur. I'm producing the documents. I'll file it at the counter, my lord, or I'll hand it over. I'll
Yes,
file it at
you
the
file it
counter.
in the counter.
Please.
You serve a copy to.
I will do so, my lord.
Yes. The request of counsel for the
My lord, interim order.
petitioner, reach this matter next week. Interim order granted.
It's the
earlier.
date, my lord. It is.
Yes,
Obliged.
yes, next week. You serve it today itself, man.
My lord, tomorrow, by tomorrow I'll say.
Yes.
Serial number 4, Veeresha K for petitioner, but Ramachandra Ganapati.
Petitioner in this case.
Yes,
Wife's petition, my lords. Seeking transfer, my lords, the MC petition, my lords, which was filed by the respondent husband, my lords, in Shivamogga, my lords. From Shivamogga to Hospete, my lords, where she's residing with her mother, my lords, widowed mother. And she has a two-year-old male child, my lords. One more case is, my lords, has been initiated by the very petitioner, my lords, in Hospete itself, my lords. In CMIS, my lords, and at Annex D, my lords.
He is appearing. Husband is.
Yes, my lords, they have put appearance on 30/3/2024, my lords.
Don't show learned counsel appearing for the petitioner wife. Has contended that after that matrimonial dispute, petitioner residing with her parents in Hospete, Vijayanagara district, and she has filed criminal miscellaneous 143 of 2024 for in maintenance,
Please, my lords.
for maintenance before Civil Judge JMFC Court Hospete. In that case, respondent is appearing through counsel and prosecuting the case. The respondent has filed MC number 21212 na
Please, my lords. 212 of 2023.
212 of 2023 before Family Court Shimoga for dissolution of marriage from Hospete to ಇದು ಎಷ್ಟು ದೂರ ಇದೆ?
Around 250 kilometers.
Hospete to Shimoga, it's around 250 kilometers. Petitioner residing with her 2 years old son. It is difficult for her to travel from Hospete to Shimoga to prosecute the case. Hence, he sought for allowing that appeal. When the matter is called in the morning session, none appear for the respondent. Hence, it was passed over. Even in the afternoon session, when the matter is called, none appear for the respondent. Heard the learned counsel for the petitioner. Peruse civil petition paper. It is not in dispute. Petitioner is the wife of respondent. Their marriage was solemnized on 26/4/2021. Due to wedlock, the male child was born. Now he is aged about 2 years. After the matrimonial dispute, petitioner along with her minor son residing with her parents in Hospete. She has also filed criminal miscellaneous 143 of 2024 before Principal Civil Judge JMFC Court Hospete for maintenance. In that case, respondent is appearing through the counsel and prosecuting the case. Respondent has filed MC number 212 of 2023 for dissolution of marriage before Family Court Shimoga. From Shimoga to Hospete, it is about 250 kilometers. It is inconvenience for the petitioner to travel from Hospete to Shimoga along with her 2 years old son to prosecute the case. Considering that inconvenience made out by the petitioner and considering that judgment of this court civil appeal requires to be allowed. Accordingly, CP is allowed MC number 212 of 2023 pending in the file of Principal Judge Family Court Shimoga is withdrawn. Same is transferred to Senior Civil Judge JMFC Hospital.
Great.
Serial number 21, Narendra Gowda for appellant, B Pradeep, 21, sir.
Yes, ಎಲ್ಲಿ ಪ್ರದೀಪ್ ಇವತ್ತು ಬಂದಿಲ್ವಾ? Okay, next week. None appear for the appellant. Release this matter next week.
Serial number 27, MR Irremated for petitioner, government advocate.
There are insufficient address.
Sir.
Notice issued for a third time
Sir.
for effective service of notice. None appear for a petitioner. As a last chance, week's time is granted to do the needful.
Serial number 31, Manjunath ND for appellant, Janardhan Reddy.
ಎಲ್ಲಿ ಅದು ಮಂಜುನಾಥ್ ಇದ್ರು ಬಿಡಿ.
ಮಂಜುನಾಥ್ ಅವ್ರೇನು NOC ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಬೆಳಗ್ಗೆ ಹೇಳ್ದೆ, ಅವ್ರಿಗೆ ಇಂಟಿಮೇಶನ್ ಮಾಡ್ದೆ, ನಾವ್ NOC ಕೊಟ್ಟಿದೀವಿ ಇದ್ರಲ್ಲಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅವರೇ ಇಲ್ಲ ಅಂತ?
ನಾವಿಲ್ಲ, ನಾವ್ ಏನೋ ಪೇಪರ್ಸ್ ಎಲ್ಲ ವಾಪಸ್ ಕಳ್ಸಿದೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಆಯ್ತು, ಬಂದ್ ಕೊಡ್ದಿ, I will dismiss it, that's all. ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್.
ಓನರ್ ಮೇಲೆ ICICI ಮೇಲೆ ICICI ಬ್ಯಾಂಕ್ ಮೇಲೆ ಲೈಬಿಲಿಟಿ ಫಿಕ್ಸ್ ಆಗಿದೆ. ಯಾಕಂದ್ರೆ ವೆಹಿಕಲ್ ಲೋನ್ ಕೊಟ್ಟಿದ್ರು ಟ್ರ್ಯಾಕ್ಟರ್ಗೆ. ಟ್ರ್ಯಾಕ್ಟರ್ ಲೋನ್ ಕೊಟ್ಟಾಗ ಅದು ಲೋನ್ ಡಿಫಾಲ್ಟ್ ಆದಾಗ ವೆಹಿಕಲ್ ಸೀಸ್ ಮಾಡಿ ಸೋಲ್ಡ್ ಟು ಸಮ್ ಅದರ್ ಶ್ರೀನಾಥ್ ಅನ್ನೋ ವೆಹಿಕಲ್ ಸೇಲ್ ಮಾಡಿದ್ರು. ಪಾಲಿಸಿ ICICI ಬ್ಯಾಂಕ್ ಮೇಲೆನೆ ತಗೊಂಡಿದ್ದಾರೆ. ಆಸ್ ಆನ್ ದಿ RC ಬುಕ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿಲ್ಲ. ಸೊ ಇವರು ವೆಹಿಕಲ್ ಮಾತ್ರ ಸೇಲ್ ಮಾಡಿದ್ರೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಆಸ್ ಆನ್ ದಿ ಡೇಟ್ ಆಫ್ ಆಕ್ಷನ್. ಸೊ ಅದಕ್ಕೋಸ್ಕರ ಆನ್ ದಿ ಬೇಸಸ್ ಆಫ್ ಪಾಲಿಸಿ ಮತ್ತೆ ಬಾಂಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ರಿಂದ ಈ ಓನರ್ ಇವ್ರ ಮೇಲೆನೆ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಸ್ಯಾಟಿಸ್ಫೈ ಕೂಡ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು, ಬಟ್ ನನಗೆ ಅದು ಐಡಿಯಾ ಇಲ್ಲ.
For compensation of rupees 1,70,000 with interest 6%. 1 and 2 are jointly and severally. 1 and 2 ಯಾರು?
ಬ್ಯಾಂಕ್ ICICI ಬ್ಯಾಂಕ್ ಮತ್ತೆ
ಅವರು ಇಬ್ಬರ ಮೇಲೆ ಮಾಡಿದ್ರು.
ಹೌದು.
ಆಯ್ತು, ICICI ಬ್ಯಾಂಕರ್ ಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಂತಾರ ಅವ್ರು. ಬ್ಯಾಂಕ್ನರ್ ಎಲ್ಲ ಕೊಡ್ತಾರ ಬಿಡಿ.
ಅಲ್ಲ, ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ನೀನು
ಅದಕ್ಕೆ ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂತ. When the matter is called in the morning session, none appear for the appellant. Even afternoon session, when it is called, none appear for the appellant. It appears that 2 weeks time is granted to take steps in it. The appellant is not interested in prosecuting this appeal, means dismiss for non-prosecution.
Pending application.
All pending applications are disposed of.
Serial number 33, Kashinath JD for appellant, HS Lingraj.
Waiting for applicant, my lord.
ಇದು ಲಾಸ್ಟ್ ಟೈಮ್ ನಂಗೆ ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಆಗಿದೆ.
ನಿಮಗಾಗಿದೆ?
ನಮ್ಗಾಗಿದೆ 24.
Will condone the delay.
28/11 ಆಗಿದೆ. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅವರು.
You have not served a copy to him.
Served ಆಗಿದೆ.
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕಾಪಿ ಕೊಡ್ತೀನಿ ಇನ್ನೊಂದು ಕೊಡ್ತೀನಿ.
ನೀವು ಒಂದು ಕಾಪಿ ಕೊಡಿ ಅವರಿಗೆ. Yes. When do you want, Mr.
2 weeks ಕೊಡಿ. ಅದು ಚೆನ್ನೈಗೆ ಅದು ರಾಯಲ್ ಸುಂದರಂ.
Counsel for the petitioner is directed to serve one set of copies on counsel for respondent number 2. Please this matter after 2 weeks. Yes.
Lordship, delay
ಕಾಪಿ ಕೊಡ್ಬೇಕಲ್ಲ, ಅವ್ರು ಇಲ್ದೇನೆ ಡಿಲೇ.
ಕಾಪಿ ಆಲ್ರೆಡಿ ಸರ್ವ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಬಟ್ 2019 ಮ್ಯಾಟರ್ ಅದು ಅಗೇನ್ I am serving copy, my lord.
ಎಲ್ಲಿ ಸರ್ವ್ ಆಗಿಲ್ಲ? ಎಲ್ಲಾಗಿದೆ ಸರ್ವಿಸ್ ಮೇಡಮ್?
28/11 ಲಲಿತಾ ಕನ್ನಿಗೆ ಜಸ್ಟಿಸ್ ಲಲಿತಾ ಕನ್ನಿಗೆ ಅವರು
Lordship, respondent number 1, I have the acknowledgement, Lordship.
On 28/11/23, this court has directed him to take notice.
29/11/23 ಗೆ respondent number 1 and 2 ಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀವಿ. 29/11/2023 ಗೆ
ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
1 ಸರ್ವ್ ಆಗಿದೆ, 2 ದು ಕಾಪಿ ನಂಗೆ ಸಿಗ್ತಾ ಇಲ್ಲ.
2 ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
ಸರ್ವ್ ಮಾಡಿದೀವಿ.
ಎಲ್ಲಿದೆ acknowledgement?
PF ಕೊಟ್ಟಿರ್ಬೇಕು ಮೇಡಮ್ ನೀವು.
ಇಲ್ಲ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರು, ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡ್ತೀನಿ. ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್ಡ್ ಮೈ ಲಾರ್ಡ್, ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡ್ತೀನಿ.
Yes. Leave this matter up to 2 weeks. ಅಂತ ಅಂದ್ರೆ on 28th August.
ಮಚ್ಚೊಬ್
Serial number 38, Harish Babu K.N. for appellant, B. Pradeep.
Yes, Mr. Harish Babu. ಎಲ್ಲ ಇದ್ರಲ್ಲ ಬೆಳಿಗ್ಗೆ.
ಇದ್ರು sir.
ಪ್ರದೀಪ್ ಇಲ್ಲ ಹೇಳ್ತೀನಿ.
Case of death. ಎಲ್ರಿ ಅವರು ಬೆಳಿಗ್ಗೆ ಎಲ್ಲ ಇದ್ರಲ್ಲ ಅವರು. Harish Babu. He is not there. Yes. Leave this matter next week.
Serial number 46 ಒಂದು ಡೇಟ್ ಬೆಳಗ್ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಶುರು ಮಾಡಿದ್ದ ಮಧ್ಯಾಹ್ನ ಟೈಮ್ ತಗೊಂಡ್ಬಿಟ್ರಂತೆ. 46 ಒಂದು ಡೇಟ್
ಮಧ್ಯಾಹ್ನ ಅದೇ ಕಂಟಿನ್ಯೂ.
ನಾನು ಅಲ್ಲೊಂದಿತ್ತು ಅದ್ ಮೂವ್ ಮಾಡ್ಬಿಟ್ಟು ಬರೋಣ ಅಂತ ಹೇಳಿ ಹೋಗಿದ್ದೆ ಅಷ್ಟೊಂದು.
Yes, next week ಹೋಗಿದೆ.
ಡೇಟ್ ಅಂತ ಕೊಟ್ಟಿನಿ.
Next week ಅಂತಂದ್ರೆ next Wednesday.
Yes, let's and one more submission. Serial number 8 ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಕರಿಬೇಕಾಯ್ತು, ಅದು ಮರ್ತು ಬಿಟ್ಟೆ ಹೇಳೋದು. Serial number 8 ಅಲ್ಲಿ Serial number 8 ಅಲ್ಲಿ 8.1 8.1 ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿಲ್ಲ, ಅದನ್ನ ಬಂದ್ಬಿಟ್ರೆ ನೋಟಿಸ್
ಅದೆಲ್ಲ ಸೈನ್ ಆಗಿ ಹೋಗಿದೆ ಆರ್ಡರ್ ಶೀಟ್. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಯು ಮೆನ್ಷನ್.
Yes, yes.
ಬರ್ಲೇ ಇಲ್ವಲ್ಲಪ್ಪ. ಏನ್ ಮರ್ಯಾದೆ ಇಲ್ಲ. ಆರಾಮ ಸರ್? ಮೇಡಮ್ ಅದೊಂದು ಸಪ್ರೇಟ್ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಬೇಕು, ಮಾಡಿಸಿಕೊಡ್ತೀನಿ. ಹಲೋ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಕೊಡಪ್ಪ, ಇಲ್ಲ ಅವ್ರಿಗೆ ಅಕ್ಸೆಸ್ ಆಗಲ್ಲ. ನೀವು ಏನ್ ಮಾಡೋದು ಗೊತ್ತಾ? ಬ್ಯಾಗ್ ತುಂಬಾ ಎಣಿಸ್ತಾವ, ನಾನು ಮಾಡ್ಕೊಂಡಿಲ್ಲ. ಏನ್ ಎಣಿಸ್ತಾವನ ಅಂತ ನೋಡಿದ್ರೆ ದುಡ್ಡು ಎಣಿಸ್ತಾನ, ಹೋಗೋದ್ ಕಳ್ಸಿದೀನಿ ಅವನಿಗೆ.